but the matter never appeared.
Which number?
I am giving.
Item number?
It's not in the list, madam. The file is here. Unfortunately, madam, they are not releasing the matter. I don't know.
Okay.
But yes,
move on urgent, not motion.
the number of a director has been disqualified. But after the disqualification has been done, the director of several companies to that to comply with the statutory requirements, not filed for documents for the company.
Today is not the mentioning date. Raman has it.
Thursday. But kindly engage with me, this is a new matter and very urgent.
What is the urgency?
Urgency that is
So why you not mentioned yesterday, Monday? Mention on the mentioning. Today only I will take the unlisted motion.
The tender matter,
If you're not having the decorum of the court to give the senior to say first making the submission, then this will not allow any of the submission of. Tomorrow to be mentioned.
Urgent matter, tender matter, your lordship directed the state authority to fix the rate and broad-based committee report and place before your lordship. They took 3 times adjournment, lordship, and your lordship fixed it on 20th August. But lordship, we have published one rate and directed to be giving effect for 1st August. First one that started the lordship. 1st August. They are going to effect, giving effect that.
What?
They are rate, lordship. They have prepared rate and directed the authorities, other
rate prepared means what is the rate? What the rate prepared?
Lordship, we have prepared, lordship, I do not know. Lordship, we have supplied it to the concerned persons to give effect for 1st August. Lordship, fixed on 20th August. Same for matter. Lordship, kindly take it out Thursday or Friday, any day, lordship.
You are telling the writ written, what is this now? You file a new writ written.
Lordship, that is challenging that order, lordship.
31st ko rakho. Issue notice to the other side, 31st within 10 minutes.
Lordship, may I please go?
Huh? What is the urgency? You?
Lordship, not what is not. It is not extremely situation. I'm seeking there is a rally.
Rally since the independence. It is not that for the present situation.
Has to be
Mr. I am telling you, when I have taken the first determination, this clash has done. I have called the report. I call the report from the CS, I call the report from DIG, but none of the officers have filed any report before this. And with I am telling in the open court, with the consent of the liar, the file has gone out of the list. And you are moving the urgent here I know showing him between the court officers and the lawyers and the file. Maybe, but what I have tried my level, but your authority is not coming forward. If the authority is not intent to the rules and all these things,
tomorrow.
30th.
May I permitted to,
30th within 10 minutes.
may I permitted to move in this urgent motion, madam. We are the madam peerless association, madam. Now peerless nagar association, madam.
Sorry. The election could not last for 1.5 years. We wrote a letter before the authority. Now ultimately it has been decided that we wrote to the appropriate authority, who is the special commissioner under the apartment membership act. Special commissioner directed the subdivision officer to take immediate steps in the controversy and the dispute here. Now thereafter subdivision officer has not taken any steps. Then second reminder, now the situation day before yesterday there were due to non-action. I will kindly direct the subdivision officer to take immediate steps in terms of the direction passed by the special commissioner 3 times for election, my lord. But this is in a chaos situation, my lord. What is, my lord? Kindly grant me leave. I will soft copy everyone. Kindly fix it on Monday. Subject Monday or any day.
Who will conduct the election?
Subdivision officer.
How the subdivision office will
Under the apartment ownership act, kindly see the order, my lord. The special commissioner apartment ownership act, my lord. Once, my lord. This is the first order. Then thereafter, my lord, 3 order has been passed upon the special subdivision.
Who has passed an order?
Special commissioner under the apartment ownership act, my lord.
Special commissioner order has not been complied with the subdivision
This is
officer.
the situation now. What is in the present state of affairs? Kindly let it appear on Monday, my lord. I will serve everyone, my lord.
So the notice come on 4th.
Extremely.
Within
May I
10 minutes.
please permitted to mention very urgent matter, lordship, tender matter, lordship. The technical evaluation already published, lordship, tomorrow evening, lordship. The petition name has been deleted because, lordship, first tender notice was issued, the NIT. In that tender notice, petition name was there. All on a sudden, that tender has been cancelled without assigning any reason. Thereafter, they publish it, club 3 serial at a time and publish the NIT, lordship.
So you participated in this,
No, I immediately made a representation there. How this has been done? This is a violation of Article 14 and Article 19(1)(g).
why after cancellation whether new tender cannot be published?
So
Where is the violation of where is the violation of article?
Some reason is to be given.
It is necessary.
Why
Reason is
this
to be
has been
given.
done? Only
Reason
the
is to be
tender has
given.
been cancelled.
Sir, if the tender is cancelled and fresh tender has been put on published, so you will get an opportunity. You go and go and participate.
No, what they have done, lordship, 3 serial number was there. They clubbed together and published the one single tender. This is nothing but they want to give this work order in favor of the particular person. Because of that reason, this has been done. Was a new motion, lordship. Kindly take it.
When the notice was published.
Notice was published, lordship, 15 days ago.
Then,
Thereafter, I filed the repetition, lordship.
then, so what do you want now? You have already filed the writ petition. What do you want now?
A new motion, it is not appearing in the list, lordship.
Not appearing in the list.
So
What
the
is-
urgent motion, kindly take it. Otherwise, lordship, the writ will be in fact.
I am telling every day, I am ready to take all the matters subject the bar come at 9:30 till 6:30. I will take all matters. And to avoid the not to attend. These 3 you come with this court, I will take all the new motion matter every day from 9:30 to 6:30. I am ready. You take the decision and with the condition not to take any resolution, not to attend the court. These 3 conditions you come, I will take every day 9:30. Even I will sit at Saturday also. I am ready to accommodate all the lawyers. If you are telling, no, this court is not taking the new motion, I will take that. Come, take the decision, come 9:30 till 6:30, I will sit here. No problem at all. Even Saturday I will take. All new motion I will take. The urgent motion, what the urgent motion? That is not a new motion.
That is
Then?
motion, but lordship,
Yes, call
kindly
the
take
list.
directly to lordship. Kindly take it.
I'm sorry.
Submission of the bar. See the submission of the bar.
Everyone has their own. I need to take it in.
Give the direction to the matter that we appeared in the urgent motion of.
Urgent motion में कर दो, Wednesday कर दो, तब within 20 minutes.
of my company. The matter was appearing at serial number 12 on the 22nd. When the conviction was brought to your lordship notice, they did not make us parties if your lordship recalls not. Mr. Abhatosh Mujumdar, who appeared on the 22nd, he on his personal ground, and the matter was thereafter fixed by the lordship on 28th, that is today. But today it is appearing as item number 142 and 143. Any day convenient to the court, this is the 12 and 13 was on 22nd. Shall any day, even if your lordship fixes it, first is a working day, any day convenient to the court, any day. Within the first,
Who is for the other side?
Mr. Srijit Chakraborty, I have indicated to him, though I'm not mentioning it on formal notice. 142, 143.
142, 143 একটা কাজ করুন 6 তারিখ को रखो 6 तारीख को within 15 matters करो.
Great.
Lordship, my indirect
Today there is a in the list. Not in. Why you not mentioned yesterday? Why you not mentioned yesterday? At की आज के तो हाँ 2 बजे.
But it is a tender matter. I am the highest media. Your lordship already had this matter and passed an order to the director of agriculture to consider my detention. They are not considered on the ground. One unsuccessful bidder is claiming that he is the first one.
He is the
He is the first L1. Thereafter, I move one petition before your lordship, and your lordship on 10th June, your lordship was direct to file opposition and matter appear on 16th July. Matter is running in the list. They are going to cancel my tender process. Your lordship only direct the agriculture to consider me
what consideration?
my prayer.
What is a prayer?
Pardon?
What is a prayer?
That is to consider me as a.
It is going to it is to be heard on merit because affidavit.
They are going to cancel.
If they cancel, the new cause of action will come, sir.
I'm entitled to get the.
So if you are entitled to get and they cancel, then the court will see to that. Pendency of the writ application, you are cancelling that, then the court there will be.
Second thing, I move this petition before your lordship pass an order. 5th February 16th July, they are not filing the opposition. No reply. The lordship only consider my representation and this. Only consider my representation. The lordship can 105.
105 कल नहीं परसों टू बी मेंशन में रखो. Yes.
This is not unlisted, but I missed mine. Today, yesterday was mentioning the director identification number has been disqualified. Because of the disqualification, the petition is subsequent. He is a member of the director of 14 other companies also. So all the statutory compliances have been stopped. Kindly, anyway convenient.
It is not listed.
It's not listed. It's not.
May I have your lordships kindly.
एक काम करो उसको 5 तारीख को रखो.
I'm so
Within 10.
May I?
I'm so good.
If like this, the court will entertain all these things. I will sit up till 4:30, only taking the matter of the mentioning. I will not hear any matter. Yes, I will sit here. I will take all mentioning matter till 4:30, and you go tell to the bar, tell to the CJI, tell to the media. The court is not taking the matter, only taking the mentioning matter. What can be done? Like your matter, there are hundreds of matter. The freezing. If I will allow your matter, then tomorrow she will ask. Then he will ask. Thousands of matter, the freezing matter is pending before this court. Every matter is having urgency. If I will not allow like this, only I am allowing which is urgent required.
May I have your lordships kindly? We will have to mention this matter. Mother could not have come yesterday because on Thursday last week I had filed a matter, made it returnable today. It is not on the list. The problem is that my steering license has been suspended on last week under an instruction which puts a suspension without any hearing. I will not give
License?
Stevedoring
Stevedoring.
and show handling license.
That is, I think, fixed, sir.
Yeah, it was returnable today.
It is not listed.
And each day I come returnable, made returnable today. I am each day
7 तारीख को रहेंगे.
grateful, your lordship.
Akshay,
Grateful. None at the one.
Where is our unlisted?
Extremely obliged, your lordship.
Where is our unlisted? Where is our writ petition? Maybe it is filed. How it can be said the unlisted? Once the writ petition is filed, how it can say that it is unlisted? Can you say the unlisted? What is the unlisted motion? Then say that. Then, so what is the urgency? What is the urgency?
Matter regarding election of the society. Itself is
Lordship, I'm seeking leave to file an SIR matter. Agency that the petition is a NEET PG candidate who is in the recruitment process. In time, I will call for document verification process.
When you file the SIR,
Seeking leave, your lordship.
what is the necessity for seeking leave? File and give the notice. Every Friday the SIR matter is taken up.
Lordship, may I be permitted to mention one new motion matter? The petitioner is suffering from end-stage renal disease. The kidney transplant is very urgent. He
Who is the donor?
a common friend.
Common friend. What is the linkage of the common friend? Have any interview was done by the authorization committee?
We have complied with all requirements.
Whether the interview was conducted by the authorization
Yes,
committee? What is your statement before the authorization committee?
Interview has been done. They have not communicated any decision.
Not communicated.
Not communicated any decision. My lord. Kindly, can
आठ तारीख को रखो. Yes, call the list.
First, and is I couldn't have bothered your lordship, but now the other bank accounts are being freezed of petition.
Like this, madam, you the advocate will come.
I'm just requesting
उसको 11 तारीख को कर दो. Come on Thursday. Come on Thursday. Yes, call the list. Call the list.
My lord, I am appearing for the page 41 is the appeal. 40 and 41.
Why it is to be mentioned?
My lord, on the last document, my lord, my case was not under adjudication, my lord. My case was deleted. My name was deleted in the first unmapped category. So accordingly, I filed and preferred an appeal before the DEO, and that appeal is at
Will
page
file before the
DEO, district
district election officer.
Election officer, my lord. And thereafter, my lord, it was pending since April, my lord, and I have additionally filed a form 6 also, my lord. It was taken up by your lordship, my lord, on the last occasion when
Where is your appeal before the DE?
My lord, page 40, my lord.
This is not before the tribunal.
This is not before the tribunal, my lord. This
Your
is a
lordship,
different.
as I had appraised your lordship, there are certain cases. This is an internal document. I'll just hand it over, your lordship. Kindly see paragraph number 2, last 4 lines.
But 41 is the performer of the appellate authority, appellate officer.
My lord, this is the officer, my lord.
First of the DO district election officer. Second paragraph, last 4 lines.
Well, these are the cases, my lord, where the cases were not sent for adjudication by the judicial officers, my lord.
That's correct. That is still the demand is pending. Okay, let he decide. This appellate officer decide this.
My lord, that is the as per the statute.
Had become the judicial officers in terms of Supreme Court's order. They are not the DOs which had done that.
No. That's why I'm asking, because kindly come to the page 41.
My lord.
Page 41, when you file this?
This
I have filed in April to
the entire task was done by the judicial officers.
My lord,
It can't, it is in terms of Supreme Court's
my
order.
lord, it cannot be, my lord. That is what I am submitting, my lord. My lord, because my case was never sent
Your
to
lordship passes a judicial order accordingly.
No.
Because the procedure was
No,
there
page 41C, there appeal number, this appeal number is registered where?
before the district election officer, DM. This
DM.
entire task was handed over to the judicial officers in terms of Supreme Court's order.
Acha,
That's why we
when
cannot.
the tribunal was constituted?
Tribunal was constituted sometime in April.
Acha, then all the file was sent there.
Now, from the DO's order, whichever order was against, it went.
So I am passing an order that the appeal be sent to the tribunal, and tribunal, if received, the tribunal will dispose
The
of.
stage of tribunal did not reach.
That's why, so let the election and the appellate officer.
Your lordship passes an order that let the appropriate authority dispose of the application instead of specifying.
No, but
who it
but
is.
this is appeal file. So appeal file, they cannot ask after the Supreme Court order, after the appellate tribunal has been established. So now this appeal has to be remitted to the appellate tribunal.
No, my learned friend could not file any appeal before. There is no document showing that she had filed an appeal before the tribunal.
I cannot file, my lord, because my lord, the portal was not allowing, since my case was never sent to
That's why.
adjudication.
So page 41, kindly see.
It is before the DO.
DO. So you are telling that whatever the appeal pending before the DO, before the constitution of the appellate tribunal, all the appeal has to be taken care by the appellate tribunal.
My lord, may I indicate?
How the appeal has come?
First stage is BLO, who takes Form 6 and processes.
Correct.
Any aggrieved party would file it before the DEO, District Election Officer.
Correct.
From that, it is going to the SIR tribunal.
Correct.
It is pending before the second stage.
My lord, may I indicate the notification which has been published for the constitution of the tribunal, my lord?
Page number 30.
Page 37, my lord. The first paragraph. My lord, the tribunal can entertain the appeals which are under adjudication, cases which were under adjudication.
No, for the electorals who are the under adjudication will be able to submit the appeals against the inclusion and exclusion of the name as online in the website order. So you have submitted this.
My lord, no, my lord, my name was never gone for adjudication. My name was deleted at the first instance, my lord.
Correct.
So, my lord, that is why prior issuing of this notice, I have already filed appeal before the DEO, my lord.
So this is to be disposed of. DO is to
Yes,
be
my lord.
disposed of.
That is what I am.
So you are telling.
And
So,
also
but
Form 6 has been filed for as a deleted.
there is a Form 6.
My lord, Form 6 also filed, my lord.
Form 6 can be disposed of by the authorities.
That
It
is
is not.
authority. That's why there is a confusion.
My lord.
If you come to the page 41, that is the appeal.
My lord.
And page 45 is the Form 6, which is to be disposed of.
My lord, may I pray, my lord, the appeal has to be disposed of. My lord,
How? Unless and until the Form 6 is not been decided.
my lord, the issue is that, my lord, I have filed the appeal prior to filing of the Form 6, my lord. My lord, having no other, my lord, there was lots of confusion, my lord. People were saying you go and file Form 6, my lord. There I have.
Then on May you filed fresh appeal before the election.
My lord, that was a representation to consider, my lord. That is not an.
There's a memo of appeal. Kindly see the page 48.
My lord, I have seen, my lord. My lord,
Yes, that is again an appeal before the CO.
My lord, that's a representation, my lord. My
No.
lord, the statute
How
provides,
it
my
can be said? Kindly see the headlines, memorandum of appeal, grounds of appeal.
my lord, that appeal is also required to be filed through portal, my lord, only. My lord, once an appeal is being disposed of by the DEO, my lord, then I can go.
You do one thing. You take report of this.
My
What is the situation? Take report, then you come.
If required, we will process a Form 6.
If if authority is processing the Form 6, inform that. If not, then the order is required, then I will
Your
discuss.
lordship.
The learned advocate, because there are three things he has
My lord,
taken the three
admittedly,
steps.
yes,
So
ma'am.
which steps has been taken will be decided by the authority. If the authority will say that they will not decide, they will send back and send the matter to the tribunal, then the matter has to be sent to the tribunal. Then the appeal number is to be registered, then they will issue
Your
that.
lordship.
The Land Council for the Election Commission. press for time to take instruction from the authorities whether any application or adjudication of the name of the petitioner for induction, the name for induction is pending, induction in the electoral is pending or not. Let the instruction be taken on or before. By Friday, you will take.
Your Lordship, it will take 2 weeks.
My lord,
I'll provide, if I.
By
receive the
7th of August
instructions, I'll provide it to my
7th of August 2026, let the matter appear on 7th August under the SIR matter at the top.
my lord, grateful, my lord.
Next. Yes.
Like,
May it please, Your Lordship.
Item
This is for
number
extension
two.
of interim order, my lord. An interim order was granted in our favor on 14th
Before my
14th
lord,
of July, my lord.
my lord, one thing which I need to indicate, on last occasion, my lord was pleased to pass this interim order. However, my lord, the petitioner has not made the asset reconstruction company at whose behest this Form C was issued and Form D
My lord,
was.
my lord, we have filed an application.
Once again, Mr. Bhatt. He has not deliberately not made a party, and they challenged a Form D. Now, my lord, kindly see the last portion of the interim order that my lord has granted. It's very clear. In respondents, obviously, asset reconstruction company is not a party. It shouldn't be binding me. Respondents are restrained from taking any benefit of Form D when it is mentioned that the authentication completed on such and such date. This is the interim order. Now, my lord, kindly see how they are misleading National Company Law Tribunal and my Section 7 application by stating that High Court has stayed the proceeding. Firstly, they don't make me a party in a proceeding whose behest this Form C
My
and
lord, I will now make submissions.
it's an order now goes to National Company Law Tribunal and misleads this court by stating that High Court has stayed this order.
My lord, may I very humbly submit? Although I'm not. My lord, may I only indicate this? I'm not appearing before the NCLT, so I do not, my lord, know what has happened, but I have instructions. My lord, before NCLT, they were seeking to proceed on the basis of this Form D. Because that's my lord, they have not stated for once that they will not rely on this Form D. In fact, my lord, it has been, Mr. Guha, may I only submit? It has been submitted by them before the NCLT. This I'm submitting on instructions, my lord, that they said that this order is not binding on them, and hence they want to proceed before the NCLT. Because the difficulty is they could not have proceeded because this Form D is what they are relying on, and that is why we have taken out an application because of their statement before the NCLT that this order does not bind them. We have taken out a separate application for adding the asset reconstruction company as a party in the proceeding, my lord. And we have made a prayer there that this interim order be extended to cover them so that they can't make the submission before the NCLT. So there is no hide and seek. What Mr. Guha is indicating that perhaps we have misled the tribunal by stating that that's factually incorrect. So Mr. Guha should not be submitting that we have misled the tribunal. We have indicated, in fact, they have sought to mislead the tribunal by saying they are not bound by this order. And that is why we have taken out this application for adding them as a party in the present proceeding with a specific prayer that this interim order should be extended to them so that they can't make this submission before the NCLT. It's the doctrine of committee of courts, what they are doing. There's an order by which they are restrained and they go before the NCLT and say, no, this is not restraining us because we are not party in this present proceeding.
Sir, has to be mentioned, this court find that the petitioner has filed an application in CAN 1 of 2026. Let the CAN, you have received the CAN?
My lord, I have received the CAN.
Yes, what is the submission?
Well, that is now they want to make me a party. Obviously, I don't have any objection. But my lord, what is pinching me is this interim order. My lord,
I am not extending the interim order.
My lord, may kindly clarify.
Interim order extend.
My lord, kindly. My lord, kindly,
my
lord, the interim order, my lord, was granted.
Application for extension.
My lord, I am for the respondent number 3. My lord, kindly consider the main point, the jurisdictional point, my lord. Whether the
my lord, may I only submit this, my lord, before my lord takes a decision.
The petition has filed an application being CAN 1 of 2026, praying for addition of Reconstruction Enterprises Private Limited with the packet as respondent number.
The other respondent, my lord, this
number
is 4, my lord, respondent number 4.
As respondent number 4. Cool. This court find that that the presence of the added respondent is required. Accordingly, the petition is allowed to the add the reconstruction. What is that? The Reconstruction Enterprises Private Limited as respondent number 4.
Respondent number 4, my lord.
Respondent number 4, and to serve notice upon the respondent number 4. Serve upon the respondent number 4. Full stop. The petition is directed to amend the cost title and to serve the amended copy of the writ application to all the respondents. This is the matter.
My lord, may I only pray, my lord, the last paragraph 6 of the order dated, my lord, 14th July, my lord, restrain them from, my lord, relying on this, because this, on the face of it, my lord, this is bad in law. Form D.
On 10th of August 2026 under the heading
that NCLT may proceed independently. My lord, may kindly clarify.
No, my lord, I'm objecting to that. My lord, they can't. My lord, they can't.
What is happening, my lord?
My lord, they can't, because my lord, they are relying on this. My lord, they are relying on this document, Form D.
The added learned counsel appearing for the added respondent has brought to the notice of the court passed by the learned tribunal, National Company Law Tribunal dated 23rd of July 2026, wherein the petitioner has taken the benefit of the order passed by this court dated 14th July 2026. But now the said order was up till 23rd of July 2026, and the petitioner has not prayed for extension of the said interim order on 23rd of July. As on date, there is no interim order.
I am for the respondent.
The
My
learned
lord, kindly do not do that. My lord, the only
affidavit in opposition leave is granted if subject to your lordship satisfaction.
Yes.
Affidavit in opposition has been made ready, my
My lord, may I?
Learned counsel, you are appearing for?
Respondent number 3.
My lord, may I only submit?
Affidavit in opposition, let us with the record petition liberty to file reply within a week thereafter. Leave the matter on 10th.
My lord, may I only submit this, my lord? The only difficulty is, my lord, if the NCLT proceeds with this, my lord, they will rely on Form D. My lord, may I only pray for this indulgence? My lord, if it is recorded by your lordship that they will not rely on this document, my lord.
This is not time. You are having the total group of the advocates, but every time you are not mentioning the matter. Only after the period is over, you are coming with the mentioning for extension of time. Sorry, and you are not filing an application. Sorry, you
My lord,
cannot.
may I only submit this? My lord, may I only submit this because, my lord, it was indicated in the order.
The advocates are mentioning the matter before this court a day before, 2 days before for extension of time, even on the date also. But your juniors are not competent to mention the matter, and after expiry after 4 days, how the court can extend the matter?
My lord, may I only submit this? My lord, perhaps the language of the order is, my lord, that on 23rd the matter would be listed in the meantime. So, my lord, till the matter is heard, my lord, there is an interim order which is subsisting. My lord, may I only submit this? My lord, kindly consider this, my lord. My lord, kindly consider. Lordship, may I?
To raise the point of mention, the same is kept over. Yes, who is for the respondent number 4?
I'm good.
Item 4.
Item 3.
My lord, may I only submit, my lord, may I only request if an earlier date is kept, my lord, for the hearing of this matter, because, my lord, otherwise, my lord, will face a difficulty in NCLT, my lord.
Item 3, who is appearing?
Well, I appear for the petition.
Yes.
My lordship would kindly come to page.
I'm deeply obliged, my lord, deeply obliged.
Lordship would kindly take up page 24 of the repetition 1.
Where is your affidavit?
My lordship. This is my affidavit of service. But kindly takes up page 24 of the repetition 1s. Now, but I shall not be bothering your lordships, my lord, with the entire order. Turns to page 25, last paragraph.
Yes, all respondents are appearing.
But they all are appearing.
Mr. Trivedi, you are appearing for?
I'm appearing for the railways.
Railway.
Railways is the prime respondent. Your lordship takes up page 25 once. Now, there was a proceeding before the National Green Tribunal Eastern Zone Bench. Now, with regard to my lord, kindly takes up page 25, last paragraph. Now, there was an issue that my lord, some properties of the railway were encroached. Now, the National Green Tribunal directed that we are informed that the illegal occupants in the area in question have not been provided opportunities of individual hearing, although it is stated on behalf of the railway authorities that orders of eviction have been issued on the basis of a common representation submitted by them. We are of the view that each of the illegal occupants ought to be heard separately and separate orders passed against each of them as cause of action would arise in each case of each individual. But thereafter, if any order has been issued to the detriment of the encroachers, fresh notices be issued against each of them and heard individually before any order be passed. This is an order dated 2nd November 2017. We are not granted any opportunity of hearing. What is done is, if your lordship takes up page 22, on 24th July 2026. Page 22. On 24th July 2026, this is dated 30th September 2018. It's pasted on the wall of the petitioner clerk offices.
30th of September.
Yes, the notice is dated 30th of September. Served on 24th July 26, which is almost 8 years. You can opportunity of hearing. Kindly sees the tenure of the order. Prior to the Honorable Court's order dated such and such under reference above, one order for removal of unauthorized structure in railway line from both sides of the road around Chhatravati Jham has already been passed by the against the authority Chotodol Club by Southeastern Railway number such and such. The organization to vacate road immediately. The celebrated 30th October 2017 has been passed by Southeastern Railway after serving properties as well as giving personal hearing to your representative. So, November 2017, Tribunal Instance Zone Bench, such as the authority of Chotala was asked Southeastern Railway 1st May 2018 at 17:30 hours in the office of the Honorable by notice such and such. It was dated 5th May 2018 has been listed on the road with this is by railway, where the organization refused to accept the same. The representation of the data personal only. So fixed on 21st May 2018 at 17 before the undersigned. However, the undersigned example of your organization on the basis of available records of Southeastern Railway as well as the representation of railway administration's representative such and such, and the following order is passed. It is found in the office records at Southeastern Railway that your organization of unauthorized agricultural occupants activities there making it unauthorized measuring such and such. The Chhatravati Jheel at Howrah. As per records of Southeastern Railway, it is found that the railway line in question, Chhatravati Jheel at Howrah, is no longer allotted or transferred in favor of the organization of the Southeastern Railway. After they proceed, and when it comes to the last paragraph, therefore, I hereby direct the authority of Chotodal to vacate the question from the date of publication of this order. The order is passed in 13 September 2018, but they not granted us any opportunity of hearing in terms of the order passed by the National Green Tribunal. But they say that they have posted the notice, but they say that they have signed it by persons of the railway, and thereafter, almost 8 years, suddenly a notice is issued to us. This is a permanent grant us an opportunity of hearing, but in terms of the order of the National Green Tribunal, when it comes to the last order, it's possible for the National Green Tribunal, if your lordship is taking up page 28 once, which is disposed of on 4th of July 2022. The National Green Tribunal had directed the Southeastern Railway to submit a report as to what was conducted by them based on the earlier order, which your lordships have seen. The lordship comes back it's 26 months. It's an interim order passed by the National Green Tribunal. The National Green Tribunal directed should be following this regard by the respondents on the next day. List on 15 December, ultimately on 4th of July 2022, let the railway authorities say whether they have conducted a hearing, whether they have filed a report in that regard before the National Green Tribunal. In such time, grant us an opportunity of hearing, we shall participate in the hearing, and in the meantime, let the operation of this notice be stayed. Because it is absolutely in violation of the order passed by the Green Tribunal. Before the Green Tribunal, we are not even parties.
Yes.
Essentially, what is done is saving an order of the National Green Tribunal. I don't think these two take
Who is appearing for the railway authority? You are appearing, yes.
Yeah. What we have learned is that first they should show their right for coming before this honorable court. That person cannot be a climber and claim relief on the shortcomings of the authority, which is governed by the Railway Act, and Section 147 is all imbibing. We are not liable to give any hearing to anyone, and we can evict them under 147, and that is the law of the land upheld by the Honorable Supreme Court. That is my first point. Now, my lords, what is, my lord, the locus standi, or what is his authority to occupy this land? His lordship kindly comes to the first page of the petition. Their sole claim regarding the land is that they are a club. If my lords kindly comes to the first paragraph, their credential for occupying railway land, which is basically Moti Jheel, which is a bird sanctuary. It's a park which is for the public who use that for their own purpose. Now, Lordship, I will also rely on the footpath judgment of the Honorable Supreme Court latest, where it has been said that that is a fundamental right. You cannot make construction on passages which is belonging to the land, and this is a sanctuary which is a bird sanctuary. Be that as it is. Lordship, the first paragraph, the only credential which they have, it is that they are a club which was established in 1960 and it was registered in 1982. And they indulge in welfare activities. Now, Lordship, not even a single document to show their right in respect of that particular land which belongs to the railway and to occupy the same. Now, the best case which they have made out before your Lordship is this, that under an order of the learned Green Tribunal, they were given an amnesty to attend the hearing to be given by the railway authorities and ventilate their grievances before, as a last chance, before being evicted. That is an amnesty. That is not a matter of law or a right with Germans. Now, Lordship, from there, we have stated that we had given them, now Lordship knows a club, how it functions. Lordship will also have to understand the grassroots reality. Whenever there is a club, it's a group of people, we don't even know who's the secretary, who is the president, where is their abode. Now we go and give a notice to them, nobody accepts it. Because we are working under an order of the learned Green Tribunal, we have fixed it. After that, we asked them to come for hearing, nobody attended, we have got all the record sheets there. When nobody attended, we had to pass an order, which is at page 22, which was placed. Now, Lordship, will kindly see, we passed an order. After that order, that was communicated to them at that point of time. But Lordship knows that it's a club, there can be a law and order situation, and till the NGT appeal, matter was pending, till 2022, the matters were there. Then, Lordship, in 2022, NGT decided and directed to remove all the encroachments. That I'll place later. After 2022, Lordship, then we once again reiterated this order that this is an order which has been passed in 2018. Kindly vacate. Otherwise, now they have come before this honorable court. Now, Millets, the take on this particular subject is, Millets, first point is this, Millets, that they have no right. Forget about title or interest in the property. Admittedly, the land belongs to the railways. Admittedly, it is surrounding a bird sanctuary, a lake, which is being used by public at large and also for railways at the time when it is required. The matter went before the NGT because of encroachment, which was contaminating the lake and was creating problems. Therefore, the learned NGT passed an order for removal, but so that nobody should be condemned without being heard. Therefore, a direction was given to us to hear them out, which we did. And then when they suffered an order, they were enjoying illegally that particular portion. Now 2022, and they are saying that we were not party to that particular proceeding. When we called them, they are not supposed to be a party to the proceeding because they don't have any right, title, or interest over the land. Now, Lordship, in 2022, when the NGT decides I should remove the encroachment, then I start my proceedings. Now they are coming that you give me hearing, you leave me the. Now, Lordship, I'll take my lords to the pleadings which have been made by them. Now, Lordship will kindly allow me to come to the order of the railway, which is at page 22.
Yes.
Lordship, here categorically and without any doubt, we have mentioned whatever was.
What the green tribunal held finally?
Lordship will kindly come. Lordship will kindly come to first to page 28. My lord will kindly come. That is the green tribunal's order, final order, and my lord will take lordship.
Page 38.
To page
38 is over.
If my lord will kindly first come to page 34. Situation was, what was the situation? Why these things were? Yes. My lord, here, Pollution Control Board, the corporation, everybody were working in tandem. It is page 34, my lord will kindly see. Paragraph 7, subparagraph 4, then 9. Until arrangement is made for reallocation of encroachments, the government of West Bengal is duty bound to take steps for prevention of pollution of Satragachi Jheel. So, my lord, this was the reason that we have to remove encroachments. Now, my lordship will kindly come to page 37, which is the finding and directions. If my lord kindly comes to page 38, subparagraph D, 11 subparagraph D. Railways may take steps to remove encroachment within 3 months from the periphery of the lake to the extent of the area falling in its jurisdiction in accordance with law. So, my lord, in 2022 also, we have given a clean go by the learned Green Tribunal that you remove encroachment. Now, coming to the law of the land lordship. 147, if my lords kindly see, this is the hearing notice which we had given. We have got all the documents which they did not even appear.
No, this kindly see serial number 10.
Lordship.
Who is the petitioner here?
Yes,
Chota Dal Club. Chota Dal Club.
My lord is petition. Lordship.
No, you are this.
Yes, my lord.
Kindly see the 10, not service.
No, my lord. My lord, we have given hearing to all the encroachers. Some of them came.
No, this
my lord, they did not come because that is the case made out by us.
Okay.
At that order of 2018. That lordship, what happens if a particular gentleman is occupying, we can go and find him and give it. Here, nobody was wanting to take. So we affixed it. My lord kindly allows me to place the order which was passed and which was given to them, that ex parte order, which is at page 22. My lord, it categorically states, my lord, what happened on that particular day. If my lord kindly comes to page 28, 22, I stand corrected. Third paragraph. May I please? The said notice dated 15/5/2018 has been pasted on the wall with the sign of 2 number of witnesses by railway when your organization refused to accept the same. Your organization neither submitted any representatives nor turned up on the date of your personal hearing, so fixed on 21/5/2018 at 17:30 hours before the undersigned. However, undersigned examined the case of your organization on the basis of available office records of South Eastern Railway as well as representation of railway administrative representative dated 21/5/2018, and the following orders were passed. It is found that the office records of South Eastern Railway that your organization are unauthorized encroachers occupants over the land in question and activities thereon by making an unauthorized hut measuring 10 meters by 4 meters, and that is 40 square meters near Satragachi Jheel at Howrah. As for records of the Eastern Railway, it is found that the railway land in question around Satragachi Jheel at Howrah has never been allotted, transferred in favor of your organization by the Southeastern Railway at any point of time, and therefore your organization are not the licensee of the said railway land under the Southeastern Railway authorities, and your organization has also no legal or contractual right to continue to occupy the said railway land in question, and there is no agreement or statute entitling your organization to occupy the railway land, and your organization are not authorized to make such structure thereof. Then lordship will kindly come to the next portion, It is further observed that your organization are not only encroaching, trespassing the said railway land in question, but
Yes,
are
that I
also-
have gone through.
Now, Millards will kindly appreciate the third paragraph of page 23. Please note that as submitted by the Southeastern Railway in their representation, temporary licensing allotments so and so are not connected with the railway works has been banned by the government of India since 1984. Now, Miller, they are saying 1960, 1982, 1984. Since 1984, it has been banned, so we cannot give them at all. So, my lords, now they stand on a footing where they have no right to be there. They are creating nuisance. There is a NGT order saying remove the encroachment, which is in final form, which does not give them any right. And even audio alterum partem, my lord, this is disputed question of facts. Lordship, this honorable court may not go into.
Yes.
And Lordship, 147 is very clear. And my lord, we have judgments. If my lord kindly sees,
Hey, railway একটা আছে?
niche, na? Sorry. Look, this is the place, my lord, where the latest decision of the Honorable Supreme Court, 2026 SCC Online SC 1162. My lords will.
2026 SCC online.
Lordship, I'm handing over a copy, my lord. I apologize, my lord, it's not finished.
No problem.
My lord, this is only paragraph 20, which is on page 6, which is on top, my lord. Yeah, my lord, of course, it is on use of footpath and right to walk. I am drawing a parallel only with the fact that these encroachments on lands
Yes.
do not have any right to encroach because they are a hindrance to the common citizens. You may do welfare for your own welfare. You occupy a land and then you come and say audio alterum partem not being in hearing, and when you are asked to come to hearing, you don't turn up.
Yes.
So one cannot take advantage of his own wrong. This is, my lord, the first, my lord, judgment. Now, lordship, if my lord kindly, my lords will kindly have a look. If my lord has Railway Act, my lord, I apologize, my lord. My lord will kindly see 147, my lord, which has been amended, my lord, on 19th of June 2026, my lord, but not to include become all imbibing. But my lord, what I am on is 147. If my lords, the latest amendment is parameteria to this section. My lord, I will place that also, because that amendment my lord's book may not have it,
Yes,
because
it
it was in June.
It is not here.
My lord, June 2026. My lord.
Because court is not updated, but the lawyers might be.
My lord, we learn, my lord, through doing matters, lordship. Lordship will kindly see, if any person enters upon or into any part of the railway without unlawful authority, or having lawfully entered upon or into such part misuses such property or refuses to leave, he shall be punishable with imprisonment. Lordship, this now I come to 2, lordship. Any person referred to on subsection 1 may be removed from the railways by the railway servants or by any other person whom such railway servants may call to his aid. Now, my lord, the honorable, this honorable High Court has decided, my lord, that under 147 we do it. Now, my lords, here we were directed to give a hearing. We have given that hearing. Now, this is a disputed question of fact, my lords, as to whether they were informed or not informed. And lordship, if any order has been passed, it has been passed by the NGT for removal of all encroachment. Now they should go to the learned NGT.
Yes.
Their right lies alternative remedy there.
Yes.
And as far as railway is concerned, lords, we are now, lordship will kindly see one compilation. I'm just, my lord, all the judgments I would not place. If my lord kindly sees, the first is an unreported judgment. WPA 18248. My lord, here, my lord, encroachment on the railway platform was there, and lordships will kindly see, if my lord kindly comes to page 14. Page 12. Internal page 11 of the judgment.
Yes.
My lord, the coordinate bench of this honorable court. In these paragraph 19, Lordship. In these such circumstances, this court does not find any reason to interfere with the decisions of the authorities. However, the railway authorities have already allowed such persons who have been in unlawful occupation to approach them after completion of projects under the scheme for license lease of shopping complexes, etc. This indicates that the authority has considered the question of livelihood and that decided to permit a person to run their business on certain terms and conditions from developed complexes and under compliance of eligibility criteria. The decision has to be taken by the railways in public interest. Well, this is about public interest who are carrying. Then below the last paragraph 20, which says, holds that 147, we are well within our rights. Now, Lordship, kindly flip over the page. And my lord kindly comes to page 16. This particular matter was assailed in appeal before the Honorable Division Bench of this Honorable Court, which is at page 16. That is MAT 1603 of 2024.
Yes.
Lordship, the Division Bench of this Honorable Court was pleased to uphold the decision saying that 147(2), if my lord kindly comes to paragraph page 18, internal page 3, paragraph 9. It needs to be noted that the members of the cooperative society cannot be treated to be an unauthorized occupant. Rather, they are trespassers of the railway land, and in terms of section 147(2) of the Railway Act, they are entitled to be removed by the appropriate authority of the railway administration.
Yes.
Now, Lordship will kindly see the last portion, that is at page 19, paragraph 17. The occupants of the railway lands are directed to peacefully remove the encroachments and vacate the area, failing which the railway administration is entitled to remove all the trespassers and all encroachers for which purpose the superintendent of police of the district shall afford necessary police protection on a request made by the railway. Now, Lordship, this matter was assailed to the Honorable Supreme Court. Anamika, mere ko do. मेरे पास एक नहीं वो नहीं. Well, this matter was again assailed to the Honorable Supreme Court of India, which was once again, if my lords kindly comes to page, the last 2 pages of the compilation, which I have given. Last 2 pages. My lord will kindly see the parties. Chandanagar Station, Miller. This Miller. There, my lord, the Honorable Supreme Court also was of view that, my lords, if my lord kindly comes to page 2, last page of my compilation, paragraph 2. Under these circumstances, we do not see any illegality in the eviction order issued by the railway authorities for removing the encroachments from their lands, including the shops run by the petitioner society or its members. Now, Lordship, here there was an semblance of Article 21, which is being argued in other matters before the Honorable Coordinate Bench. But here there is no semblance of Article 21 also, Lordship. It's a particular society which champions for the cause of doing certain work. And in support of whatever welfare activities they do, the annexures which they have put, Lordship, is social activities. Allos will kindly come to page 30, annexure P2. Drawing classes, Durga Puja celebration.
Page?
Allos will kindly come to page 30, 21.
Yes.
My lords, will kindly see the electricity bill is at page 20, which does not give them any right, lordship. And my lords will kindly take up page 21. My lord, old club image, 24 hours ambulance service that can be done by any NGO without occupying a government land. Then, lordship, funeral car service that also can be done without occupying government land. 24 hours oxygen cylinder service that also can be done without occupying my land. Cold water supply. Children park, the park is already there, let them play. Your club need not be there. Then Lordship, yoga practice classes, dance practice classes, karate practice classes, drawing practice classes, Durga Puja celebration. I am very happy, my lord, the Durga Puja should be celebrated. Then, my lord, garment distribution, all these activities, Lordship. Do they require that particular encroached?
What is the area?
My lord, it is, my lord will kindly again come to the order of the railway.
40 square meter. 40 square meter, so many activities.
My lord, it is, my lord, the activities are also, my lords, will maybe they are using the other portion of the park or any other place, you know. So this is the long and short of their case.
Okay.
So, my lord, in my respectful submission, my lord, they are, my lord, on a larger public interest. It's a bird sanctuary. NGT has taken cognizance that these encroachments are creating all type of nuisances, and therefore, my lord, pollution control Board, and there has been a order, my lord. Now they cannot come and say, my lord, that they have not got audi alteram partem cannot be their case.
Yes.
And lordship will kindly, last but not the least, my lord, if my lord kindly sees balance of convenience and inconvenience, public at large, and this particular organization which is championing for the cause of the public at large and in order to justify its encroachment. So, my lord, that cannot be, my lord, justified. My lord, this man, I'm grateful.
I'm appearing on behalf of the Havra Municipal Corporation. I have very limited submissions to make, your lordship. I would pray before your lordship to kindly come to page number 37, the finding and further directions.
Yes.
9 and 10.
Yes.
We have heard 8, paragraph number 8, your lordship. We have heard learned counsel for the parties with a view to pass final order in the light of proceedings in the last more than 6 years. As noted earlier, main issues which call for decision are prevention of pollution of lake, which my learned friend has just ventilated, by preventing discharge of untreated sewage from the Havra Municipal Corporation and Railway Colony, and removal of encroachments from the buffer zones / periphery of the lake. 9. The earlier orders noted above show that the municipal corporation has to treat 82% sewage and railways 88%. Land is to be given by railways. Pending dispute is about terms. The stand of the state authorities is that they have prepared a rehabilitation housing scheme known as Banglar Bari for resettlement of the encroachers. But since the encroachment is on railways land, the railways must provide land. 10. The penultimate paragraph. We are of the view that on account of pendency of such above dispute, Municipal Corporation, Havra or the railways cannot claim right to discharge untreated waste into the lake, which is a criminal offence. Basic responsibility is of the corporation to prevent such discharge. Giving land for settling encroacher is not the obligation of the railways under any law. Thus, the Municipal Corporation, Havra, must set up appropriate STP pollution control mechanism to prevent gross sewerage entering into lake, as they are generating 82% of sewerage. STP along with garland drain may be designed and operated as to comply with the standards of water quality at least B class as per orders of the tribunal in respect of wetlands and such and such. All sources of sewage and its drainage carriage system may be properly intercepted and diverted to STP. Accordingly, 11A, your lordship. Municipal Corporation Havra may take steps in the light of observations in para 10 to set up necessary STP along with garden drain within 4 months to prevent discharge of untreated wastage into the lake by incurring costs from its own sources initially and sorting out its claims against the railways separately. And D and E, railways, there is a direction for the railways, and E, which is a direction for the district administration. So this is the limited role which the Havra Municipal Corporation has been directed to play. These are my humble submissions.
Yeah, to assist my lord, what has been said primarily is an order of the National Green Tribunal. My lord will be pleased to take page 10, my lord. Paragraph 10.
Yes.
Petitioner stated that it is unfortunate that this has been followed by the respondent authorities, and the hearing has been conducted on a repeated basis by the National Green Tribunal without giving a fair opportunity to the petitioner to present his case, which is gross violation of law and of the principle of natural justice. But takes the next page, page 11, paragraph 11. Your petitioner for the state service that during passing such supreme order, the opportunity has been given to the petitioner to present their case before the authorities and petitioner also by the pass the judgment, the respondent authorities without acting in terms of the order, we on submissions, to the national green tribunal, explaining that the successful defense. So, their remedy, if at all, assuming lies before the national green tribunal. Either they will have to pray for recalling of that order, review of that order, or whatever, or they will have to go up to the Honorable Supreme Court, under the NGT Act of 2010. That is the remedy. Here, before asking this Honorable Court, without having the records of the Green Tribunal proceeding appeal, over or assailing the order of the Green Tribunal, perhaps would not be the right thing to do. Also, when a petitioner comes before court, sitting in this jurisdiction, they will have to also demonstrate their bona fide. Where is their sanction plan of the building which they have constructed over the said land? They have constructed some building, then they will have to have some sanction plan, some authority sanction in accordance with law. But always coming before the court and saying that right of hearing to whom? In what cases? And under what circumstances, man? So, this has to be properly demonstrated by the petitioner before my lord. That I have a sanction plan. As per the sanction plan, I have constructed a building. Now, some respondent authorities there is some order. They are trying to encroach into my land or evict me from my property. So, therefore, this right of audio ordinance partnership cannot be used as a sword. It is a shield at best. What is being purported to be used in repeated matters, is using this right of personal hearing, right of hearing the other side audio ordinance partner as a sword, not as a shield. So this is not a practice which is appreciated. I'm so grateful.
Okay. May I give a very short reply? And may I give a 2-point reply?
One more point, Millard. My the pollution control board may have overseen it. See, my lord, under the Environment Protection Act 1986, my lord, and also under the constitutional principles, lordship, Article 48A obligates the state to protect and improve the environment and safeguard the forest and wildlife. And this is a bird sanctuary, Milord, and the Jheel is also there. So, Milord, this particular now, Milord, audio alterum partum.
If it is a bird sanctuary, why the wildlife forest authority has not taken any steps against them?
Well, Wildlife Forest Authority was also before the NGT.
No, why they have not taken? Because in the Forest Wildlife Act, there is a special provision for prosecute the persons who entered into the sanctuary.
Because this sanctuary and this club is totally different.
Maybe, Milord. I don't know, but Milord, I'm just off the cuff. I'm answering, Milord. Because this encroachment was on a railway land, so it was a duty incumbent on the railway to remove them. But Milord, because of the NGT's order, which came in 2017, we were again bound by that order to give them a hearing. We gave them a hearing. Then the NGT matter came to a logical conclusion, giving us full right in 2022 to remove them. Accordingly, we started the process. So now, Milord, they cannot come, and very rightly said by my learned friend, that they are challenging the NGT order. They are challenging my 147. And then they are saying that they, without having any semblance of right. So, Milord, therefore, maybe Forest Department will take care of them and will prosecute them accordingly.
Yes.
But may I give a 2-point reply?
Yes.
Takes up page 34 once. But this was the affidavit given by the state before the NGT. My lordship would kindly see paragraph 7, then 4, then 9. But the stand of the state was until an arrangement is made for relocation. Lordship has seen that. But secondly, they are trying to evict me on the basis of an order dated 2nd November 2017. That order clearly directed the railway authorities, my lord, to file a status report as regards the procedure for encroachment. Now, my lord, that order crystallized into the order dated November 2022, which was the final order passed by the NGT. Now, thereafter, in the entire order, your lordship will not find but a single line as to what eviction procedure has the railway authorities adopted, based on that interim order. Now, my lord, lordship will see 11D, in which, my lord, the railways were directed, my lord, the language used is they may take steps to remove the encroachment. Now, my lord, what I am on is, my lord, when the NGT order, my lord, became final in November 2022, it was incumbent upon the railway authorities to issue a fresh eviction notice in terms of the order of November 2022. What they have done is, my lord, they have proposed to evict us on the basis of an order issued in September 2018 and which has been served to us in July 2026. Now, what I was only praying about, I am not challenging the order of the NGT, but I am only saying the mode and manner in which the NGT has directed the respondent authorities to act, they should act in terms of that. And these are my submissions.
The petitioner has filed the present writ application challenging the action of the railway authority for eviction of the petitioner from without giving any opportunity of hearing. Land Council for the petitioner has relied upon the order passed by the learned National Green Tribunal dated 2nd November 2017, wherein the learned tribunal has directed the authorities the illegal occupant before eviction of the illegal occupant, an opportunity hearing is to be given to the illegal occupant. Then counsel for the petitioner submit that the railway authorities, without complying with the order passed by the London Tribunal, London National Green Tribunal, and without giving any opportunity of hearing to the petitioner, are trying to evict the petitioner. Full stop. The counsel for the petitioner further submit that subsequently the tribunal has passed the final order on 4th of July 2022, wherein the tribunal has directed the authorities to take appropriate steps for removal of the encroachment. But even after the order of the tribunal dated 22nd of July 2022, the authorities have not issued any notice or no opportunity of hearing was given to the petitioner before the eviction of the petitioner from the land in question. Per contra, Leonard ASGI appearing for the railway authorities, ASGI submits that after the order passed by the Leonard National Green Tribunal dated 2nd November 2022, a notice was issued. Then counsel for the petitioner further draw the attention of this court to the communication dated 13 September 2018, wherein the railway authorities have passed an order to vacate, directing the petitioner to vacate the land in question within 15 days from the date of publication of the order. By referring the said notice, the counsel for the petitioner submit that the said order was also passed without giving any opportunity of hearing. He further submit that the order was passed on 13th of September 2018, but the railway authorities are going to execute the said order on 24th of July 2026 without giving any opportunity or without serving the said copy of the order. Per contra, an advocate the London ASGI appearing for the railway authority.
I am now ASG.
Sorry.
No, it is still not synced in. Even I am not synced in myself.
Appearing for the
I apologize, Millard.
Sorry, no, I have appearing for the railway authorities. Submit that in terms of the order passed by the National Green Tribunal dated 2nd November 2017, the railway authorities have issued a notice to the petitioner, but the petitioner failed to refused to accept the same, and accordingly the notice was pasted at the premises by fixing the date of hearing on 21st of May 2018 at 17:30 hours. The And counsel appearing for the railway authorities have also handed over the document showing that the notice, several persons have appeared in terms of the said notice, but the petitioners have not appeared in the said notice, appeared before the authority in terms of the said notice. Accordingly, after hearing the parties and after going through the records, as the petitioner has not appeared before the authorities, the authority came to know that the petitioner are in illegal occupation of the premises and passed the order dated 13th of September 2018. And counsel appearing for the railway authority further submit that though the order was passed in the year 2018, but the matter was pending before the London National Green Tribunal, and the National Green Tribunal has disposed of the matter on 22nd of July 2026 by directing the railway to take steps to remove the encroachment within 3 months from the date of 3 months from the periphery of the lake to the extent of the area falling in the jurisdiction in accordance with law. In compliance of this said order of the London Tribunal, the respondent authorities is executing the order dated 13th of September 2018. Now, counsel
Tribunal is dated 4th July 2022.
Now, counsel for the railway authorities further relied upon the judgment in the case of Chandan Nagar Station Area Hawkers Cooperative Society Limited, represented by Sri Devabrata Day versus Union of India, passed in WPA number 18248 of 2024, dated 22nd of July 2024, and submit that the similar matter came before this court, and this court has upheld the order of eviction passed by the railway authority. He further submit that the said order was carried in the appeal as well as before the Honorable Supreme Court, and the Honorable Supreme Court has upheld the order of eviction. He further submit that under Section 147 of the Railway Act, it is not necessary for giving any notice to the petitioner. But in the present case, the railway authorities have given the notice to the petitioner in terms of the order passed by the tribunal dated 2nd November 2017. But the petitioner failed to appear before the authority, and the authorities have passed the impugn order. Thus, he prays for eviction of them. Thus, he prayed for rejection of the present writ application. Net counsel appearing for the municipal authorities submit that the National Green Tribunal has disposed of the matter on 4th of July 2022, wherein certain direction has been passed, and the municipal corporation, Howrah Municipal Corporation, is complying with the order passed by the London National Green Tribunal. And counsel appearing for the state authorities submit that if we go through the contents of the writ application, the petitioner has challenged the order passed by the National Green Tribunal. He further submit that if the petitioners agreed with the order of the National Green Tribunal, the petitioner has to prefer appropriate appeal before the appropriate forum, not in the writ application. He further submit that the petitioner is in illegal occupation of the premises in question, and the said has been decided by the railway authority in the order dated 13th of September 2018. But the petitioner has not challenged the said order before any court of law, and the said order has reached its finality, and now the petitioner cannot challenge the same in the present writ application. He further submitted the petitioner is in illegal occupation of the premises and is liable to be evicted. Accordingly, railway authorities have taken appropriate step for eviction of the petitioner from the government railway land. Had the learned counsel for the respective parties peruse the materials on record and the judgment relied by the railway authorities. This court find that admittedly the petitioner is in occupation of the railway land. It is the case of the petitioner that the petitioner is in occupation of said land since the year 1960, and that has been, the club has been registered under the Society Registration Act. Under the Society Registration Act in the year 1982. Full stop. It is full stop. The petitioner has relied upon the judgment and order passed by the London Tribunal dated 2nd of November 2017, which reads as follows. 25. 26 ঠিক আছে 520 in terms of the order passed by the learned tribunal comma the railway authorities have issued the notice to the petitioner for fixing the date of hearing on 21st of May 2018 at 7:30 hours 17:30 hours. It is the specific case of the railway authorities that nobody has received the notice of the notice on the side of the petitioner, and as such the notice was pasted at the premises of the petitioner. It is not only the notice was issued to the petitioner, several other persons who are in occupation of the railway land have been served the notice. And all the persons who have received the notice have appeared before the railway authorities, which appears from the note submitted by the advocate appearing for the railway authorities, which shows that the notice have been served to several persons. As the petitioner has not appeared before the railway authority, but the railway authority have considered the document available with them and come to the conclusion that the petitioner is in occupation, is the encroacher of the railway land, and directed the petitioner to vacate the premises within 15 days from the date of publication of the order. Full stop. The petitioner have disclosed the said order in the writ application be annexed P page 2022, and thus the petitioner cannot say that the petitioners have no knowledge about the order dated 13th of September 2018. The petitioner have not challenged the order of the authority dated 13th of September 2018. The specific case made out by the petitioner that the respondent authority is intending to implement the order dated 13 September 2018 in the month of July 2026. This court find that it is a specific case of the railway authorities. Though the railway authorities have passed the order in the year 2018, the matter was pending before the London National Green Tribunal. London National Green Tribunal, by an order dated 4th of July 2022, has passed the following order. It occurred page 37 to 39. In the said order, the London Green Tribunal has categorically directed the railway authority to take steps to remove the encroachment within 3 months. Accordingly, now the railway authorities are implementing the order dated 13 September 2018 by evicting the petitioner from the railway land. Considering the above, this court finds that the petitioner has no right over the property in question, and the railway authorities have already decided that the petitioner is in illegal occupation of the premises in question, and in spite of the service of notice, the petitioner has not appeared before the authority in the year 2018 itself. The railway authority passed the order of eviction on 13th of September 2018. The petitioner have not challenged the said order till date. Now, when the respondent, the railway authorities are intending to implement the said order, the petition have came before this court in the present writ application. Considering the above, the writ petition is not maintainable. Accordingly, writ petition is dismissed. Grateful.
May it please your lordship.
Yes.
In order to
yes, what is the matter?
Begin my privilege to address on behalf of the petitioner. This is an act which is of archaic legislation.
Archaic.
Constitute framed in the year 1867. Is named Shorais Act 1867. Now, each of the hotels at that point of time which were known as Shorais had to be registered under the Shorais Act 1867. Now, the impugned order passed by the subdivisional officer, which my lord would find at my lord's brief at page 102, directing to close down my Shorai, is under challenge. Now, at the very outset, I have a very preliminary submissions. The Shorais Act 1867 and section 2 thereunder, it says, the act, any implementation or any actions can only be done by the head of the magistrate of the district. And head means the district magistrate. That power cannot be subdelegated. The act doesn't say so. Now, on the very
this on the very first blush, my lord, may I just show to your lordship the Shorais Act 1867.
Yes.
My lord has found, my lord. My lord, is Shorais Act 1867 is published on March 15, 1967. Comments also from the said date. Now, my lord, kindly turns to, my lord, section 2. Lordship has found, my lord. Interpretation clause. In this act, unless there be something repugnant in the subject or context, Shorai means any building used for the shelter, accommodation of travelers, and includes in any case in which, sorry, well, only part of a building is used as a Shorai. The parts so used of such building, it also includes a pool so far as the provisions of this act are applicable thereto. The keeper of a Shorai, kindly skip for the timing. I would also satisfy, and this is required. What does it mean? Then see, kindly see section 3. On the same thing, the magistrate of the district. What you have seen,
Yes.
Magistrate of the district means chief officer
Yes.
charged with the executive administration of a district in criminal matters, whatever may be his designation.
Yes.
Kindly mark it, This is very important.
Yes.
Now, take section 3. My lord's kind wisdom, kindly exercise, to look into section 3 and section 4. Notice of this act to be given to keepers of Shorai. Within 6 months after this act shall come into operation, the magistrate of the district in which any Shorai to which this act shall apply may be situate shall, from time to time thereafter, such magistrate, kindly underline, such magistrate may give the keeper of every such Shorai in writing of this act by leaving such notice for the keeper of the Shorai, and shall by such notice require the keeper to register the Shorai as by this act provided. It's a mere registration, not license. And what would be meaning meant by the registration? That would I will also show. Now it comes to take section 4. May I continue, Miller?
Yes.
Registers of the Shorai to be kept. The magistrate of the district shall keep a register in which shall be entertained by such magistrate and such other person as he shall appoint. Is restricted for section 4 of the clerical job as a ministerial function. He shall appoint in this behalf the residences of these keepers of all Shorais within his jurisdiction and the situation of every such Shorai.
He shall appoint in this way. What is meaning that?
Miller, for the purpose of entry in the register. Which section 4 says, now section 3 for section 4.
Yes.
Section 3 says how our name is to be registered.
Okay.
Now I have to make an application. It is a mere formality.
Correct.
The moment I applied, it automatically registers. Act does not provide or say anything other than that. There is no judicial mind, no inquiry, nothing. That is the law promulgates, and that is being authored by several courts of the country, including of this court. Section 4 says how it is to be registered. It's a ministerial function. But head of the magistrate of a district, even at 1867, at that time, the emperor thought that might be done by a clerk. So he may appoint, highly see not authorized. He may appoint. The one was chosen by the legislature very consciously. He may appoint in this behalf for what was the job? For the purpose of recording the name and residence of the keepers of all Shorais within his jurisdiction. He comes to section 9. Lordship has seen,
Yes.
This is the only power which is vested Well, if my lord is not comfortable with iPad, I have the book also. I'm grateful. Lordship can take both way. Lordship can see both way.
Same thing.
It's not that.
If I will see the both, then it will double. I don't know where
No, but
which side it will go.
For me, I'm comfortable with the book.
Yes.
My lord. Now, section 9. Power to shut up, secure, clear, and deserted shoreys. If any shoreline by reason of abandonment or disputed ownership shall remain untreated and thereby become a resort of idle and disorderly persons, become in a plague or unwholesome state, or be complained of by any two or more of the neighbors as a nuisance. The magistrate of the district, kindly pause here a minute. The magistrate of the district, which has already been defined, section 2. After the inquiry, the notice in writing to be given to the person claiming to be the owner, if he be known residence within the district, and may also cause such notice to be put on some conspicuous part of the shoreline, requiring the person's consent therein, whoever they be, to secure, enclose, clean, or clear. Now, my lord, what does these 4 words mean? I show, my lord, there's an authority. And if such requisition shall not be complied within 8 days, kindly underline that. So the act provides 8 days. The magistrate of the district may cause the necessary work to be executed, and all expenses thereby incurred shall be paid by the owner of the shoreline and shall be recoverable like penalties. Kindly underline that. Under this act, or in case of abandonment or disputed ownership of the shoreline, the sale of any material found there. Now, my lord, there is no option. Nothing is left that you can close it down. You would have given a notice for 8 days to clear it. If that is not being done, the magistrate will do it, and the cost is to be recovered as a by of penalty.
Yes.
Magistrate has to ensure it's run by supplementing.
If there is any deficiency or any sort of so-called irregularities, it is for the magistrate to ensure that such being done, and if that not being done by the owner or a keeper of a shoreline, the magistrate will do it and he will realize the cost. Now, my lord, kindly see section, my lord, 14. 1-4. Lordship has seen, my lord, there is a word of penalty.
Yes.
14. Penalty for infringing act or regulations. If the keeper of a shoreline, underline this one.
Yes.
Offend against any of the provisions of this act, very important one. Any of the provisions of this act or any of the regulations made in pursuance of this act, he shall, for every such offence, be liable on conviction before any magistrate to a penalty exceeding 20 rupees and to a further penalty not exceeding 1 rupee a day for every day during which the offence continues. That this act shall not exempt any person from or liability to which he may be subject irrespective of this act. All penalties imposed under this act may be recovered in the same manner as fines may be recovered under section 61 of the Code of Criminal Procedure, within 25 or 1861. Now, let's answer the very first page. What does the keeper of a shoreline means? It does not necessarily mean the owner. Is a manager. The definition clause whether Lordship has seen shoreline.
Yes.
Then in between that, keeper of a shoreline.
Yes.
Keeper of a shoreline includes the owner and any person having or acting in the care or management thereof. That is why same alert consciously is a manager.
Yes.
I don't need to be owner of the property.
Yes.
Now, Shorai essentially needs to operate from a structure, or either from the whole structure or from any part thereof. Now, the person who shall run, he or she doesn't require to be the owner.
But what is the notice?
Yes. Now, kindly turns to the notice, page 102. The notice, page 102, it is being sent to sent by the subdivisional officer. Lordship has kindly marked. To the petitioner, secretary of the petitioner, subject closing down.
Yes.
This closing down, is exactly the same word enclose.
Yes.
Under section 9. Of lodging operation at Sanctuary Resort for operating without any Shorai license. There cannot be any license. It's only a registration which I required. I have to inform them this is the name of the Shorai and who shall operate. And we have done it 2023. Only they were required to register it. It has been brought to notice by the district magistrate and collector Birbhum that Sanctuary Resort runs by your NGO such and such is operating lodging facility on government vested land without obtaining Shorai license under the Shorai Act 1867. Since registration under Shorai Act 1867 is a mandatory prerequisite. Yes. So at the same time they say license, at the same time registration.
Correct.
For operating any lodging facility, operation is illegal. You are hereby directed to immediately seize and stop all lodging/guest house operations at the said premises with effect from the receipt of this said letter. Now it's very important. Failure to comply with penal action as per the provisions of the Shorai Act 1867 and other relevant laws. Submit compliance report to this office within 3 days of the receipt of this order. Now, my first blush that SDO did not or doesn't have any authority. Even he cannot be delegated a power. Even if the notice says that as found by the district magistrate is the sole authority who can issue notice and who can issue any direction under the purport of the said act.
Yes.
It is something, a propositions that I would be trying to develop. When act provides a certain thing or a particular act to be done in a particular manner, that is to be done in that manner only, or not at all. Lordship may recall Taylor versus Taylor, which was followed by the King Emperor, then in Supreme Court, in case of Nazir Ahmed, and Babu Varghese, which I would be referring. Now, at the very first blush of this thing, may I refer, coordinate bench of this honorable court set aside the order 2017 SCC online, Calcutta 3438.
34
2017 SCC online, Calcutta 3438.
Yes.
Kindly see is a coordinate bench. The petitioner includes a notice dated February such and such directing stoppage of a portion of a guest house belonging to the petitioner. Let's see, we have seen, my lord. Then, learned advocate for the petitioner 2 grounds. My lord, kindly do not take trouble. Kindly see para 6, which is the judgment. What was the finding? It appears that the petitioner is running a guest house at a particular plot. Para 5, I stand correct. The plot concerned appears in the record of right as Bastu. Petitioner has opted permission such and such to build the premises is concerned. It is not the case of the municipal authority that the building is not in accordance with the sanctioned building plan. The authorities complain that the land is not recorded as a lodge under the provisions of such and such. The land in question belonging such and such, a person can carry business against us. 6. Its concern, section 3 thereof requires the concerned district magistrate to issue a notice. In the instant case, no record has been placed to suggest that the notice impugned was issued to the petitioner and that the petitioner has not complied. Section 9. So that notice, issuance of notice also has to be done by the district magistrate.
Yes.
And compliance is stated there in terms of section 9, 8 days. Now, my lord, the previous notice kindly takes up page 55.
Yes.
As a lordship got my lord. Now, my lord, it was also issued by SDO. Nothing was required or nothing was asked for that you comply this. I am giving you 8 days. Say, my lord, for the purpose of assuming but not admitting, my lord, SDO also, my lord, had the authority. It simplicity a hearing notice regarding operation of Sanctuary Resort. In reference to the above noted subject matter, you are hereby requested to appear before the undersigned along with all supportive original documents in support of the lodging operation of Sanctuary Resort at such and such positively for hearing.
Yes.
So no application of mine, nothing was disclosed. My lord, for what purpose, for what, my lord, it necessitated.
What has happened now after this order?
My lord, after this, my lord, I have shown your lordship at page 102.
No, have you appeared?
Yes, I have appeared. I have gone through all the documents. Now, my lord, mine, কবে সরাইটা apply করেছো? Kindly turns to my lord, page number 37.
Kindly see to whom he has applied.
Page number?
Please hold your breath. Page 37. Malad, this is the format was given by the authority. You know, authority makes a mistake, Malad. We are being a citizen of India, we shall go by. My learned friend wants to show Malad is being the SDO before whom I had applied.
Yes.
The application form. Lordship, you have seen, Malad?
Yes, yes.
At the very top, submitted by the keeper of the Shorai. Given this such and such, well, this is the format which was issued at Bolpur. Business such and such, then name of the Shorai. Then, may not kindly see when it was received. 29th of December 2023.
Yes.
For more than 2.5 years, I had continued, my lord, uninterrupted of operation, and my lord, I have discharged my duty. My lord, the law is very clear, my lord, before the Constitution Court, I have to show my legal right and, my lord, a corresponding legal duty. Now, my lord, under this act, I have only, I submit, my lord, a form giving, my lord, information. Now, my lord, kindly on this aspect, I worked on Eric Johnson. 1989, my lord, 1988 SCC online, Allahabad 911 is a division bench judgment. Thereafter, I will show division bench of this court. Lordship has seen, my lord. Kindly first turns to paragraph 10. I would show other parts also, my lord. This is also with regard to registration. My lord has seen, my lord. Therefore, so far as the Shorais is concerned, continue.
Yes, yes.
Shorais are concerned, the only requirement is that its existence should be noted in the register. It is thus clear, no specific order has to be passed. Kindly underline, my lord. Has to be passed by any authority for registering a Shorai. Section 5 says that etc. shall be received in the Shorai. The Shorai is registered. Section 6 imposes some restriction upon the registration of keeper of a Shorai. Produce a certificate of character, etc. Therefore, the purpose of regulating the public Shorai purpose, the legislature considered that mere existence of Shorai had to be noted down in a register which was to be maintained by the state magistrate. Well, may I also continue? The statement of objects and reasons for breaking the act, besides that the primary object is to provide for the regulation of shorelines or buildings used in offices for the shelter and accommodation of travelers. Now, my lord, on the same thing, my lord, kindly have a look to our division main judgment. I'm sorry, my lord, I'm sorry, my lord, I should continue, my lord. It is thus apparent. It is thus apparent. It's my mistake, my lord, kindly forgive me. It is thus apparent that the registration of a particular building for being used as a shorai requires no formalities at all. And the provisions of the Act envisage the registration of such a building or asking. This is my case, madam. The question of a power of the cancellation of registration hardly arises. So it's a mere asking, I have discharged my duty. What was recurred in 2023 in the month of December. On the same breath, Malad, kindly see 2019-3 CHN Volume 1. I had the privilege to address this matter, Malad, before the Honorable Chief Justice, and this matter was reported. Foundation. Marshal.
Yes.
Well, it kindly takes paragraph 4 for the time being, so that, Manoj, I can make out my preliminary and prima facie foundation. Lordship has seen paragraph 4.
Yes.
Manoj, kindly take, Manoj, fifth line from that paragraph. It starts on the right side, the keeper of a shorai. Lordship seen, Manoj? 1, 2, 3, 4, 5.
Yes.
The keeper of a shorai. I'm grateful. The keeper of a shorai is defined to include the owner and any person having or acting in the care and management thereof. Every shorai, the registration of shorais to be by the district magistrate of the district concerned. This is the effect of section 4 of the Act. Not you were asking for section 4, when I said so. This is answer also by the Chief Justice. This is how the district magistrate gets the official control existence of shorai stated to the administration. Now, was registration. Now, let's get it. Register. So it is their duty. So what is sometimes called license or registration? Essentially a registration of the license. And the shorai is for the district magistrate have the shorai of ensuring that the objects the shorai are authorized. This of section 9 even this. So that should be some as for the timing, it comes to paragraph number 8. Minor Chief Justice division bench is decided that the shorai should not be stopped. Lordship single.
Yes.
Shut down. What does it mean, by registration? Kindly takes the Black's Law Dictionary. enter. Wait. For Milor's convenience, I have brought the book and also the relevant pages in a Xerox form.
Yes.
About building sanction plan. Why I am I try to show and say that it is not something a grant. It is by default, it's automatic. Now, if your lordship takes up the first page license, lordship kindly see the word granted. That state sitting the recipient of the privilege to be impermissible. Here, even no fee is nothing. And kindly make it a point, the state government till date, has not framed any rules.
Yes.
Any rules to options by their rules and choices. It cannot stop that.
Yes.
Now, it's up. Then the next page, it is the different form of license. And keep and as the third page, grant, the definition of grant. Something compensation. So absolutely is a grant of license, if that the case be, which is not in my case. Now kindly down to the registration, the first page. The definition of registration. And the very top, lordship has seen could see alert.
Yes.
Registration, the act, the country clerk, and that's the registration of the voters. That is why even the 1867 Act says the district magistrate may appoint such person for such record. It is a ministerial act. It's to be done by a county clerk.
Yes.
So, registration, my lord, I have done and I have discharged my all duties. Now, my lord, the next part, my lord, kindly turns to page 57.
Yes.
This is a building sanction plan.
Page
57, 58.
57 is the notice, hearing notice. Acha, 57.
Oh, I'm sorry, my lord.
Yes.
No, 57 is sanction.
Sanction, yes.
57, 58.
Yes.
Lordship seen, my lord? This is a building sanction plan.
Yes.
My lord, who has given this Birbhum Jila Parishad? Now, my lord.
Old age home.
Yes.
For the old age home.
It was sanctioned.
It was previously for the old age home. And subsequently, my lord, I was permitted to run commercial operations. Kindly turns to page 88. I have given all documents. This is a quote of record. When I seek a equity, I must discharge all my owners.
Yes.
Kindly turns to page 88. This is the last agreement that I had with Jila Parishad. My lord will find the previous agreement from 79 onwards.
Yes.
All got amended at page 80. Lordship see, my lord, permission for using. Lordship can see, my lord.
Yes.
Old age home such and such for running commercial purpose as prayed for. Lordship can see, my lord.
Yes, got it.
Now, my lord, total period 33 years.
Yes.
So, my lord, I was permitted a lease. That lease, lordship will see, my lord, at the very bottom of that page. Agreement dated 10/2/2022.
Yes.
That also disclosed at page 79. So, the lease deed, everything, 86. Well, I stand corrected, is 86. So, my lord, I had the permit, even if, my lord, at the cost of reiteration,
Yes.
even if there is a dispute in ownership, say for the time being I occupy illegally, but I have a right to run a shorai because there's a definition of a keeper of a shorai. I don't need to be the owner. Only in the administration and control of a particular operation of a shorai.
Yes.
And so far as section 9 says, because of the dispute, if such a shorai is going to be in a ruinous state of affairs, then only district magistrate will come and my lord give me 8 days and allow me to make it habitable.
Yes.
Which is not their case at all. Now, my lord, lordship may kindly go back to page 102 once again.
Yes.
The allegations are that he is operating lodging facility on the government vested land. At the very outset, my lord, this will go. Or even if it's a government vested land, I can run as a keeper of a shorai. If you want to evict me, you will take in due course in operation of law.
Yes.
So far as the heading is concerned, the closing down of the lodging operation for operating without shorai license. I showed it is a mere formality. I have discharged my duties.
Okay.
I was allowed to run. Is by default, it applies that is being already is a mere formality, is a mere technicality. Now, if operating lodging facility without obtaining shorai license, it cannot be a license. It's only a mere registration, a mere formality. They have to record my name. So far as all other disputes, then it says, my lord, is a mandatory prerequisite. I discharge my owners. It's a counter to it, my lord. You have to enter it. And even that does not require me to put a notice to me that yes, I have entered.
Okay.
Now,
anything further?
Yes. Now, my lord, on previous to that, my lord, there was some disturbances, my lord. I filed a civil suit. And the district magistrate was also a party. Jila Purishad, Sabhadipati were also parties.
Yes.
Page 39.
Page
39.
Yes. What is the suit for? Permanent injunction.
Permanent injunction to the nature, character, and position.
What is the stage of
My lord, there is a status quo. Kindly turns to page 51. My lord, nature is a shorai, character is a running of a shorai, and position is my position. Page 51, my lord, the bottom.
What does after 6th September?
My lord, it is being continued. My specific instruction is being continued till date. My lord, I have the pleadings also, and there are some information, my lord, at page 53, 54. These are the information slips.
No, whether the entry mode is continue or not.
Yes, continue. My lord, kindly turns to page paragraph 11. Okay, paragraph 11, page 7.
Yes.
Kindly see, my lord, 5th line from the top. The interim protection so granted has been extended from time to time and is still in force. This is my specific pleading.
Yes. Yes.
And lordship, my lord, so far as the further information slip, lordship will find it at page 53 and 54.
Yes.
And my lord, lordship may also verify and test me the affidavit portion. I say this paragraph 7 is
anything further.
My lord, anything further if my lord's required, my lord, I am ready to answer.
Yes. But I'll give you a reply on Friday. And give me 2 days time.
But
because I need
for the
some
time being, I
instruction
need
on
protection.
Friday.
Take inside law points on this.
Friday.
Regarding the status quo and the law.
My lord.
Regarding status quo and with regarding the law.
But no need to do anything because, my lord, admittedly, what I have found out from the act, they have, my lord, not placed section 5. My lord, the registration has to be there. My lord, kindly see section 5 once. Kindly see it, my lord. That is the reason I'm saying, my lord, some instruction is required. Till Friday, my lord, till now, nothing has been done. And till Friday will also
Lordship may then record, my lord, his submissions, my lord, on paper. Though, my lord, I believe.
I'll say, my lord, why it has not been placed, I do not know. Section 5 is very clear. After 1 month after giving such notice to the register as by this act provided the keeper and any sarai or any other person shall not be receive any lodge or allow any person, cattle, sheep, elephant, camel or other animal or any vehicle to halt or be placed in such sarai until the same and the name and residence of the keeper therefore shall be registered by this act provided. And my lord, it is admitted case of there, my lord, no registration is there.
Then your authorities have entered into agreement. What is for that?
My lord,
Your authorities have entered into the agreement. What
no
is for-
agreement so far as the sarai registration is concerned.
Okay.
Nothing that sort of.
Commercial purposes
Kindly
are
2 days, either my lord, on Thursday.
No sarai, but commercial purposes. And, my lord, who had the sign?
Okay.
This is the additional
Please,
document.
Mr. Basu, please, let me.
Lodging have to be registered under the Sarai Act.
Okay.
And my lord, kindly see who has my lord done it. My lord, they have applied before whom? Kindly see it, my lord, once.
ADM.
No, SDO.
This
Page 37.
is a printed
Page 37. 37. Then my lord, kindly see the next page. Page 38. We sought for this document. Till now, this has not been supplied to us. Kindly see page 38.
Yes, I have gone through. I have gone through. I have noted that.
38. And my lord, still the registration is pending.
My lord, these all documents were submitted to them. He has barely.
And not only that, my lord, no file license. My lord, DM has himself has an inquiry. I need to place that document before your lordship.
My lord, I have that.
I'm telling your lordship.
I have.
The inquiry was done by the DM. It was found there is no file license. There is no consent to operate. Lordship knows as per environmental rules. But there has to be a consent to operate. That is also not there.
Okay.
And the inquiry was held.
Okay.
My lord, these all are part of the writ petition. So far, this consent to operate and all other, my lord.
But kindly take this matter on Friday. I shall place the documents on record. Before you, then your lordship can take the call.
Learned counsel for the petition has concluded his argument. Mr. Counsel for the respondents prays for time to take instruction. Let the matter appear on Friday under the same heading within 10 minutes.
My lord, in the meantime, my lord, kindly, my lord, protect me, my lord. Otherwise, my lord,
It is there.
It's for 2 days.
2 days, nothing.
Nothing will happen.
my lord, kindly at least record that, my lord. So far as
What recording, Mr. Basu? You know the AG is appearing and he is taking time and the authority is doing something. Then I don't think the state will function like
Nothing will
happen. But ascertain in the pen is there, but here is the AG is appearing. Please
my
see
lord,
to-
so far as additional AG is concerned, since my lord, I have only for your lordship, my lord, your lordship is in the position in the matter.
Come.
Then, my lord, my affidavit of service will be kept with the record.
Affidavit kept with the
Now, my lord, one sentence. Lordship may kindly, my lord, mildest kind wisdom may record that if so necessary, lordship will, my lord, pass interim order on the.
This hearing
That
is
will
going
come up
on.
on Friday.
You're entitled to interim order, then I pass, I find that the writ petition is to be disclosed. It will be
Your lordship can file a formal
This court is not keeping all the matter once it has been taken off.
Yes,
Giving the
Regular practice of the court, your lordship hearing the matter, your lordship dispose of the matter.
Dispose
Either
of the
this way or
matter.
that.
Giving the direction affidavit going.
No, not this,
Your
not this,
lordship can
not this.
Yes, next.
My lord, may I take the book or take the book? Oh.
Yes.
Am I audible, my lord?
Item number?
I am for the petitioner, my lord.
Yes.
Item number 5, my lord.
Yes.
5, my lord, I am appearing on behalf of the state respondent, my lord. One affidavit in opposition has to be filed, my lord, but it has not been ready yet, my lord. So kindly, my lord, act on the matter.
My lord,
Petition not coming under
it may not be required.
secondary unit.
If I can allow me to place it, it may not be required. It's all on records, my lord. I'll place it, my lord.
Yes.
I'll place it, my lord. It may not be required because this is only for consideration.
They want they want to file affidavit. Let them file affidavit. How soon you will
Can I
file?
fix it?
My lord, fortnight, my lord.
And state press for 2 weeks time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply if any there to be filed within a week thereafter. List the matter on on 26th August.
Lordship,
So
take
this
up
is 10, my lord, kindly
Under the-
give some preference, my lord.
within 20 matters. Yes, next.
My lord, I am for the private respondent number 8.
I am appearing on behalf of the state, my lord.
Yes, who is for the petitioner?
My lord, before she is starting, my lord, may I be permitted to submit that on the for the self-same post, my lord, my writ petition is also pending and it was supposed to appear on 7th July to 2026. My lord, so let two matters be taken up at simultaneously, my lord, because for the same post.
Copy.
না না সেখানে তো আমার হাবিবুল খান আছে
Conjure number 7.
What is the prayer?
My lord, prayer is to
What is the case? What is the prayer?
actually it is the claiming a legitimate claim of his consideration for appointment of Mohammedan marriage register. That is the statutory framework governing such appointments with the functioning of Mohammedan marriage register in the concerned locality since 2010. He was continuously working in substantive connection with territorial jurisdiction under the discharging duty as Naib Kaji. And
But who has given the mentioning slip? Who has given the mentioning slip?
কি করেছে mentioning টা I have not, my lord.
Mentioning slips, there is something else. The matter is listed in terms of the mentioning slip. Who has mentioned the matter? You are not mentioned.
No, my.
Then who has mentioned?
Senior counsel in this matter.
Advocate for the petition, Nur Islam Sheikh. Who is the
Advocate on record.
So, what is the case? You are telling some case. You go through this mentioning list. I will dismiss the petition hearing now. Go through the. Yes, there.
Kindly.
This is not the way for mentioning.
Yes, my lord,
That's why you are giving. Kindly read. Kindly read. What is the mentioning list? Can it is connected with this?
No,
Give.
I beg
No.
your pardon, my lord.
Let you suffer.
My lord, beg your pardon.
Morning hour, this court is facing so difficulties for mentioning the matter. You mention the matter. The matter is listed as to be mentioned. After going through the mentioning, as per the mentioning list submitted by the learned advocate for the petitioner dated 20th July 2026. In the mentioning list for urgency hearing, obligation, the reason is mentioned as follows. Record this. Today, when the matter is called, this court find that what is the reason mentioned in the mentioning list totally different from the prayer made in the writ application. The petitioner has prayed for following relief in the writ application. Prayer A2. Prayer S. Who? Considering the mentioning list, concerning the reason mentioned in the mentioning list and the prayer, this court find that only to bring the case upgraded, to upgrade the case in the cause list, have willfully and deliberately mentioned the said reason, though that reason is not connected with this writ application. According to the full stop, this court find that the petitioner has the conduct of the petitioner is nothing but to mislead the court. Accordingly, writ petition is dismissed. Writ petition being WPA number 3005 of 2026 is dismissed with the cost of rupees 1,000. The amount of rupees 10,000 be paid to the legal aid service authority within a week from date. Call the list.
That I have served notice to the government pleader and as well as the other respondent.
Yes, what is the prayer?
Well, a prayer relating to the conduct of the election of our society my lord, registered under Apartment Ownership Act, my lord. I take for my lord, although this notice has been served prior to 4th May, my lord.
So Southern first note.
Another
You-
notice.
You
Well,
are appearing?
Yeah, appearing. Then, Lordship, may I hand over the copy? I have made a copy.
No, government bidder, then it again, it will be delayed.
It will be
Let's.
My lord, your lordships may regularize it.
Petition has
upon-
filed the affidavit of service, but it is found that the service has been affected to the respondent authorities prior to, in the month of December 2025. 2025. Now there is a change in the panel of the advocates, including the government pleader. Accordingly, the petitioner is directed to serve the copy of the writ application along with the document to the learned advocate appearing for the state in court today. And counsel appearing for the state has accepted the
Yes, I have
accepted the
already.
writ application along with the documents and press for time to take instruction.
Well,
How,
next,
how soon?
next,
Let the matter appear on 13th August.
13 August as the same position,
Under
my
the
lord.
same
My lord, it is with regard to the eviction and the ad hoc
Yes, sir,
committee is
record-
running
record-
illegally, my lord. My
A
lord,
meeting within 15 minutes.
much
Next.
My lord was in camera on the last day. My lord was in camera ready with the matter.
Yes.
So if
Not necessary in camera, yes.
no, stop. No, only that.
YouTube close.
Yes. Only that. Lord, with my
mentioned on the matter, my lord kept it day after tomorrow. So I was just thinking one day will take off this week. So if that matter also can be taken up tomorrow, then day after tomorrow I will not come to court. I have some personal difficulty in the house, my lord. I have to, it was Thursday, so to do this CWC and other matter, if it could be taken up, then Thursday I can take a day off, my lord, only for that. If my lord allows that, I will just fixed it day after tomorrow. No, I have to not থার্সডেটা যদি কালকে করা যায়, এটা সকালে জসের থার্সডে দিয়েছিল, এটা কালকে দিয়ে দাও না, এটা কালকে দিয়ে দাও। থার্সডে ফার্স্ট নোটিস করেছিল, কালকে দিয়ে দাও। বাট আই এম গ্রেটফুল টু লর্ডশিপ।
Supplementary just for extension.
1 minute.
It should have come up, my lord, tomorrow, but my junior, my lord, she mentioned, lordship was kind enough to keep it today only to extend the interim order. Lordship extends the interim order. We agreed, my lord, if it can be taken up next week also, lordship will come back next week.
Declaration of fraud, right?
Yes, this was, my lord, challenging a declaration of fraud in the petitioner's account.
My lord has to hear this. My lord can keep it.
Affidavits complete.
Affidavits complete. My lord has already disposed of several.
Now, we are also enjoying interim order in other matters passed by your lordship's court.
In some of the matters, my lord, my lord's favor has gone in. My lord's order has gone in my favor in some of the matters. Well, thereafter,
My lord,
it was
now in three categories of matters: lookout circular, declaration of fraud, and willful defaulter. My lord has, my lord, passed orders in both ways. So when you are depends upon the facts. Yes.
mostly that financial audit report. Those
MSN, yes, right.
Here these
My lord, this is, my lord, expiring tomorrow, my lord. It was also direct tomorrow. Yes. Yes, so lordship can just extend it and keeps it any day, my lord. Yes, my lord, affidavits complete. Okay. Very
has
grateful.
extended till
Till the next. Very grateful, my lord.
March of this.
Lordship. My lord, I the petitioner, my lord. My lord, at the outset, my lord, I apologize for having to appear online and virtually. My lord, I came to court, but I felt unwell, had to come back home, my lord. My lord, I am under instructions, my lord, to seek an adjournment for today because Mr. Kollol Basu is supposed to argue this matter, my lord, and due to a miscommunication, the matter was fixed today. My lord, miscommunication on our part, my lord. It was mentioned, the date was wrongly mentioned to your lordship. And if this could be deferred to next week, 4th or 5th of August, my lord, we would be very grateful, my lord.
The matter, your lordship, fix the matter, my lord. 86 order 93 2013, my lord, dismiss for default. Then, my lord, restoration, my lord. Well, fix after 8, my lord, your lordship, my lord.
Yes, ma'am.
Yes, completed. Yes. Yes,
Lordship.
They have not used anything. If they
Huh? Grateful, man.
Nine, I am for the petition, my lord. Pursuant to your lordship's direction, this matter also concerns CWC. Now, this is the matter, my lord. The adopted parents are before your lordship. On the last occasion, your lordship had been pleased to direct us to find out in which home the child is, so that the visitation right can be there.
My lord,
As of-
they have sent me the soft copy kindly. একটু জশাব কেটে দেখেন
And most interestingly, my lord, the report filed by them on the last occasion discloses that no order has been passed after the child has been taken by them. But preliminary, my lord, I was on that the child, the CWC cannot take away the child, my lord. Admittedly, my lord, there's an error on our part that the adoption deed is notarized, not registered or in accordance with law that should have been under HAMA Act. But on the same point, my lord, the Honorable Division Bench of the Bombay High Court had passed a similar order. And on the last occasion, my lord, I handed over to your lordship, my lord, the order of the Honorable Supreme Court, where the Honorable Supreme Court was of the view that even if the procedures were not adhered to, the child can be sent back to the adopted parents, and with a direction and a guideline that after each 3 months, the Child Welfare Committee will constitute a committee to find out the welfare of the child. Because in this report filed by them, they've admittedly said that there is no questions of abandonment or any, yes, not considered, and more importantly that paragraph 6, but I am the adopted parents. Yes, my lord. Admittedly, my lord, there was an error. Yes, no, not from us. On the 18th of February 2026, my lord, I approached a doctor in MR Bangur for medical certificate, or so that my child can be admitted. Because after 3 years with me, my lord, because he has to be admitted in a school now for his better future prospect. But yes, that is the question. But on the first day also, that this question fallen from your lordship. On 24th of March 2023, my lord, a couple, which is the private respondent number 7 and 8, delivered a boy. Due to financial constraints, my lord, he handed over that same child on the same date to us. We are issueless. We have married for quite some time, but we are issueless. We adopt the child. But admittedly, as an officer of the court, I must say that the deed of adoption was notarized, not in accordance with law. Admittedly, my lord. Now, my lord, after 3 years with me, but for his better prospects, my lord, I approached a doctor at MR Bangur so that the name of the child, or the father and the mother names, can be incorporated in the birth certificate. Now, the doctor rightly advises me that you approach the CWC, wherein they are the competent authorities. Under the CARA guidelines, that has to be done. Now, my lord, on the 18th itself, the CWC takes away my child without passing in any order, and the child remains with them since then till date. My lord, I approached this honorable court. I have written them several representations. You please let me meet the child, let me see how the child is, because there is no complaint that the child was not in a good state. Yes, my lord, we have written to them that you please tell us the procedures, we'll do whatever is necessary. Because, my lord, at the same time, my lord, as an officer, my lord, CWCs, my lord, since 18th of February 2026.
18 February 26.
Yes, my lord.
6 months, almost 6.
So what you are doing?
My lord, as per they are not the biological father, and the biological father not came to us. So the child is kept in the home. That is given as by the.
But at the same time, my lord.
So, so what is the procedure now? What procedure you will adopt? Because they are not the biological mother and father. They are the adoptive. But the adoption is not in accordance with the procedure. Correct. 3 years with them. Now They wanted the adoption to be legalized. They went for the correction of the birth certificate. Now in the correction of the birth certificate, so they went, now the corrective measure has to be adopted. If the corrective measure to be adopted, now you have taken the child from you in your custody. So the child has to be given on adoption.
Well,
Correct. So now they are the parents. So then you take instruction if they will file an application. What is called under the
But SAA, I suppose the authority.
SSA is the authority. No, the child welfare. You have
CWC.
then you has to then they have to register. You have to
It's under
register.
CARA.
Under the CARA, you have to
And
register.
carings has to be on that.
Registered, then the seniority list to be given. If it is seniority list, if preference can be given to him if the seniority is on third or fourth. Whether for this child the preference can be given to him because the child is with him only. That is to be taken into
One thing, Malad.
And what about the biological father? They are there.
They are there. They have no objection to that.
So they can, their evidence can be, then it can be declared unfit the matter and it can be given.
Yes, Malad. That can
Take
be.
instruction on that.
Well,
And Malad, on that point, Malad, in paragraph 6 of the report, they admit that there is no complaint whatsoever that
No, that's correct.
yes, I have to bow down to it.
You have to follow the
Follow the
CWC has to follow the
Yes,
procedure.
absolutely, Malad.
So now as per the CARA guidelines, once you have to register, that registration will continue for the 3 years.
Yes, Malad.
Within the 3 years, then the seniority is to be maintained.
Malad.
Correct. One seniority is to be maintained. Above than you, other persons are there, and the child is there. The seniority is to be maintained, but it has to be considered whether the child is already with you. Whether ignoring the seniority, it has to
No,
be.
child is with them now.
no. Earlier it is with
You.
Yes,
So
Malad.
now the question is, once you registered,
Malad.
so you go to the CWC, take the registration for the 3 years, and then they adopt the procedure. And if it is found that you are eligible to for, then they will issue the notice to them.
Yes, yes.
They will come. Then they will
All
declare
these procedures. Huh?
the procedure will adopt it, and then the court will find if it is that. If it is problem, then the court will pass a judicial order.
Absolutely, Malad. That was followed. The Honorable Supreme Court has passed the same line. That's hand over the child, follow the procedures.
Follow the procedure. Follow the procedure.
Because the procedures are handmade. And Malad, in paragraph 14 of my application, if your lordship kindly sees, I've specified the emotional content of the mother. Both the parents are before your lordship.
it is better.
And at this moment, I'm only praying for visitation right. In the meantime, they can follow the procedures. Malad.
No, I will pass an order. You will be given a vegetation rights twice in a week.
Yes, Malad.
Twice in a week, and in the meantime, the court will also grant you leave to go and register with the CARA.
My lord, all
register with the CARA, and if you register, the authority will take appropriate steps.
My lord.
Correct, and this will be
better take the biological father mother also, so that
there's no order passed by the
or otherwise you do one thing. You are submitted. You ask your authority what would be the procedure like this situation. If they say if the court will fix the line, then I will fix the line. If they will do, then I will direct to do like this.
My lord, I will take instruction.
You take instruction. For the time being, okay. The petitioner has filed the present writ application, praying for a direct
Government of West Bengal.
upon the respondent authority.
Government of India. Get a copy. Okay, get a copy.
What you have prayed for?
My lord.
Directing to furnish the details of the records pertaining to the minor, namely Amit Das, for removal of the custody of the minor from the petitioners to the SSA with the Child Welfare Committee. Then counsel for the petition submit that. The child was born on 24th of February 2023 as Bangur Hospital, Kolkata. Bangur Hospital, Calcutta. Full stop. Immediately after the birth of the child, the biological parents being unable to look after the child have given the child in adoption by way of registration, by way of a notarized adoption deed. Since the date of birth, the child is with the petitioners. All of a sudden, full stop. When the petitioner had applied for you are approached the authority.
Paragraph 8. I had approached the
When the petitioner had approached no, with regard to this.
I'm just coming. Paragraph 18. I had approached the MR.
Petitioner tried to obtain the birth certificate, corrected birth certificate by incorporating the name of the petitioners as parent as mother and father, comma. The petitioner were asked by the Child Welfare Committee to hand over the child to the committee. Accordingly, the child is with the Child Welfare Committee, and the Child Welfare Committee have not returned the child to the petitioner. Full stop. Then counsel for the petitioner submit that as the child is with the petitioner since the birth, that is on
4th of March.
On and from 24th of
March 2023.
24th of February 2023. 24th of February 2023. Only on when the child was taken to the CWC.
18th of February
Only on
2026.
18th of February 2026, the child was taken by the CWC, and since then the CWC is not allowing the petitioner to see the child, and as such, at present in the interim measure, the petitioner prays for allowing the petitioner for visiting child to visit to see the child who is in custody of the CWC, and in the meantime the petitioner will take appropriate steps in consultation with the CWC for legally adoption, for completing the procedure for adoption of the said child legally. Then the concept appearing for the state has submitted the report and submits that the petitioner, though the petitioners have taken the child in adoption, but without following the due process of law. And as such, the CWC had no other alternative but to take the child in their custody. And the child is with the CWC, and at present, and the child is at Society for Indian Children Welfare. What is the name? Child is at the SSA, namely
Society for Children's Welfare.
Society for Children Welfare. Children Welfare at 20 and 22 Cornell Bishwas Road. 20
and 22.
22
Cornell Bishwas Road.
Road.
Begbagan, Calcutta.
Kolkata. ठीक है. Full stop. Considering the submission made by the counsel for the respective parties, it is not denied that the minor child, since the date of birth, was in custody of the petitioners. Only after the period of 3 years, the custody of the child was taken by the CWC, as the petitioner have not adopted the legal procedure for adoption of the child. The petitioner has to take appropriate recourse to adopt the child legally. In the meantime, this court find that the petitioners should be given visiting right to see the child twice in a week by the CWC. Accordingly, CWC is directed to allow the petitioners to see the child twice in a week for 2 hours. For 2 hours from 11 a.m. to 1 p.m. on every Thursday and Saturday. Till until the further order of this court. In the meantime, the petitioner is at liberty to take appropriate steps to adopt the child legally in accordance.
At the same time, may I pray that till the completion, the child should not be handed over to any other person.
Full stop. Legally. In the meantime, but But they have not submitted any report, whether any procedure is taken.
Nothing.
So it cannot be unless and until they have been heard.
No, my lord, they have to pass an order as per the Juvenile Justice Act.
Correct.
They have to pass an order. Nothing has
So
been
in the
there.
meantime, the authorities are restrained from giving the said child to adoption to any third party.
But paragraph 22 of the
Third party. Let the matter appear on
if your lordship kindly sees paragraph 22 and 24.
20th August. On 20th August 2026, under the same heading within 15 matters. Yes, you do that.
Paragraph 22 and 24, exactly what your lordship says.
That is to be done.
That procedures can be kept aside. And at the same time, I'll pray for leave to correct the address of the respondent number 7.
Now you are also to add the.
But I'll add it.
The petition is given liberty to correct the address of respondent number
7. Mother.
Respondent number
7 minutes.
7, and also to add the SSA, namely Society for Adoption, Society for Indian Children Welfare. That is the only name.
Yes, my lord.
Only Society for Indian Children's Welfare. In course of the day,
Respondent number 8 should be corrected.
and to issue the notice to the added respondent. ऊपर जो 7 बोला ना 8 कर लो.
Respondent 8 should be corrected.
Immediately approach you file an
application. Grateful.
Madam, for the petitioner.
I'm appearing on behalf of the state matter.
Your lordship kindly, my lord, the last order, your lordship kindly see, my lord.
Yes.
My lord, after this order, your lordship kindly, my lord, I'm sorry, my lord, your lordship kindly consider this, my lord. Kindly see the, my lord, the conduct of the, my lord, the authority.
Training of field enumerator.
My lord, my lord, the matter, your lordship, my lord, for the, my lord, your lordship's, my lord, we are the, my lord, in-service teacher. We are, my lord, undergoing 2 years DLED course. My lord, the examination to be conducted by the mid of the August. My lord, we have to attend the classes regularly. My lord, attendance is, my lord, mandatory. My lord, in this situation, my lord, we are also.
Yes, you are not taking instruction and you are passing this order.
My lord, department also told me that they are seeking for some time, my lord.
So I am saying this. Take time for the years. I am fixing. I am when your training will be completed.
My lord.
When your training will be completed 2 years. I will fix the matter after 2 years. Till that I will stay your all orders.
July 27.
This is not the way of the state authority. You are asking the time and issuing the notice.
They have not informed me about that, my lord.
23rd, your lordship, the order, 25th, the order, my lord, issued this. About change the duty.
Come tomorrow with the proper instruction. Let counsel for the respondents press for time. Full stop. Counsel for the petition submit that in one hand the respondent authority is taking time from this court, and other hand the authorities are issuing the notice directing the petitioner to attend the training. In view of the urgency, let the matter appear tomorrow. The state authority is directed to come with the instruction tomorrow within 10 matters.
Grateful, man. Good.
Take instruction immediately.
I am appearing for the respondent.
Lord, I am for the petitioner.
I am directed to file a report in the
Yes.
form of an affidavit. I am filing it. I have already served a copy.
Well, this report was served yesterday, only yesterday 4:30, though it was directed to be served by 20th. I pray for before your lordship some time so that I can controvert this.
Nothing is there in the matter.
No, it cannot be. My learned friend cannot say nothing is there. That is there.
The first important point is
Yes, I shall describe everything.
power of attorney holder who is not the power of attorney holder original.
Very well.
That is said in the affidavit. That is the only first point we have to take.
The Respondents have filed report. Respondent number 4 has filed report after serving the copy to and counsel for the petitioner. Counsel for the petitioner prays for time to take exception to the report. Let exception be filed within
By 10 days, my lord, I shall file.
within 2 weeks. Let the matter appear on 21st of August
Deeply obliged, my lord.
under the same heading. Next.
Let this matter be within first 10, if your lordship so comments.
Same meeting I call. Yes, next.
Deeply obliged. নাম দিয়েছি
The petitioner in this matter. Lordship, this is the assisted reproductive technology matter. Lordship had directed me to file the fitness certificate, Lordship. This is the medical fitness certificate. Issued by them.
Yes. Who is for the state? You are appearing? Yes, what is the submission?
After the judgment of my justice, Sokosachi Bhattacharya, very less to say.
Yes, when the marriage was solemnized?
Lordship, the marriage was solemnized.
18 November 2018.
Yes.
Any issue?
No issue, Lordship.
There's no issue.
No issue. They were under treatment for a long time. First before the government hospitals. Thereafter, they were relegated to the IVF clinic. Lordship. 18th November was the marriage, 2012.
What is the age?
18. Lordship, the age of the wife is 35 years and the age of the husband is 64 years.
35.
35.
Husband?
64.
60?
4.
Huge gap.
Huge gap, yes. And the averment is there that they are ready for any donor gamete if necessary.
Yes, where is the judgment?
Lordship, this is your lordship has passed the order in another matter. This is Justice Bhattacharya's order. Canada High Court Division Bench is
Yes, recorded. The petitioner has filed the present writ application, praying for a direction upon the respondent number 2 or respondent number 4 to provide the service of
Kerala High Court passed a judgment in the division bench that should be also.
that is considered in lordship's judgment, last judgment. I had placed.
Give, no problem.
It is already considered in your lordship's last judgment. Division bench to No. Not last order records it.
क्या बोला? Service of assisted reproductive technology to the petitioner number 1. To the petitioner number 1. And counsel appearing for the petition submit that the petitioners were married on 18th of November 2018. After the marriage, they were not blessed with any issues. Thereafter, the petitioners were continuous under medical treatment. Initially, they have taken the treatment at the government hospital, but no fruitful result has come out. And subsequently, the petitioners went to the private clinic. In the private clinic, also the several tests have been conducted, but no fruitful result has come out. But in the meantime, the petitioner number 2 has become overage and the petition number 1 is the age of 35 years, due to which the respondent, the respondent number 4 refused to adopt the ART procedure as the petitioner number 2 is overage. The petitioner has produced the certificate from the same hospital?
Yes, sir.
From the respondent number 4, wherein it is certified that the petitioner number 1 certified that after careful clinical evaluation and necessary medical assessment of the petitioner number 1, it was found that the petitioner number 1 is medically fit to undergo and carry a pregnancy, and at present no medical contradictions to proceeding with the pregnancy, and she is considered to be considered fit from the medical point of view. Learned counsel for the petition submitted, though the petition number 2, being the husband of the petition number 1, is overage, but the petitioner number 1 is aged about 35 years, who is within the age limit as prescribed under law, and she can go for the ART procedure. Now, counsel for the petitioner has relied upon the judgment in the case of Sanchita Ghosh and another versus Union of India and others, passed in WPA number 12154 of 2023, dated 8th April 2024, wherein the coordinate bench of this court has considered, with regard to the bar available in section 221 within bracket G, comma clauses 1 and I and II, and held that the petitioners will be entitled to have the benefit assisted productive technology services and can approach an appropriate clinic for having such services. Full stop. The petitioner also relied upon the judgment in the case of Srimati Bula Santra and another versus the Union of India and others, passed by this court in WPA number 19776 of 2025, dated 14th of January 2025, wherein in that case also the husband was overage and the wife was within the age limit, and the court, after considering all the aspect of the matter and the clinical report, has allowed to go for the ART test, ART procedure. Full stop. Now, counsel for the respondent submit that as it is settled law by this court as well as the Kerala High Court, and learned counsel for the respondent has relied upon the judgment passed by the Honorable Division Bench of the Kerala High Court, and submit that it is settled law that if any of the petitioner who is within the age limit as prescribed under law can go for the ART test. Had the learned counsel for the respective parties peruse the materials on record and the judgment relied by the parties. Section 21G clauses 1 and clause I and III reads as follows. 831. The coordinate bench of this court has interpreted the section 21G and held that the only interpretation of section 21G and its subclauses read harmoniously with the definition of clauses as stipulated in section 2 of the Act of 2021 can give complete meaning and a wide expanse to the said act in consonance with the contemplation of the preamble of the act. The full stop. It was held that 21G of section 21G of the Act of 2021 create no unreasonable discrimination between married and unmarried women in availing assisted productive technology, and thus passes the test of constitutionality. Section 21G of the Assisted Productive Technology within bracket Regulation Act 2021 is held to be intra-virus the Constitution of India. In the present case, this could find that though the petition number 2 is the overage in terms of the section 21GII, but the petition number 1 is within the age in terms of the set provision. And as per the report submitted by the respondent number 4, that the petitioner number 1 is fit to go for clinic, is found medical fit to undergo and carry the pregnancy. In view of the above, this court direct the respondent number 4 to assist the petitioner number 1 to have the benefit of such assisted productive technology service with or without gamete. No, without assisted productive service within a period of if the petitioner number 4 to assist the petitioner number 1 to have the benefit of the assisted productive technology service in accordance with law.
Very deeply obliged, Lordship.
WPS disposed.
I have got the respondent.
Yes.
Milord, three sets of respondents are would be before your lordship. One is Milord the Kolkata Port Trust, one would be the defense, and Milord the other would be the railways, and of course the police is there.
Any department remain?
Left out, or if you left out them all.
Lordship, this is the under the duty of the defense. Already there.
বলা হয়ে গেছে মামলাটা পিটিশনার at least place the case of the petitioner.
ওর মামলা তো ব্লু জোনও নাও হতে পারে।
Milord, kindly Milord come straight to Milord page 27. দাঁড়ান দাদা বাবু
Notice inviting tender.
Yes, Milord, kindly see e-tender under 2 parts such and such for allotment of land at Chatpal Ghat on Strand Road being plot number 136/25A on long-term lease of 30 years on as-is where-is basis without renewal option against payment of annual rent upfront basis invited through e-tender, e-auction for individuals or proprietorship of a company partnership such and such. This was the tender floated by Milord, the Port Trust. Now, Milord, my clients
Who is appearing for Port Trust?
Yes. My clients participated in tender, Milord. There were many tenderers, and ultimately, Milord, kindly come to page 96.
Yes.
Milord, this is 15th of May 2026. Port Trust is writing to the petitioner. Grant of lease, this has reference to your letter date, tender number such and such. Notice inviting tender clarification addendum such and such for allotment of plot of land at the belt number 1 at Chatpal Ghat and Standard for long-term lease for 30 years without any option. Your offer has since been considered by the appropriate authority and it has been decided that the plot of land and the subject above may be leased for a period of 30 years on as-is where-is basis without any option of renewal for prospective date for the purpose of, then Milord, this purpose is given. Thereafter, Milord, the terms and conditions, this is Milord the allotment letter. The terms and conditions are given. And Milord, the general terms are given, the lease is awaited, lease will take 4 months' time. Now, Milord, kindly come to page 109. This is Milord on 24th of June 2006. This is to certify. This is to certify that the I, on behalf of such and such, this is a petitioner, the land particulars are given, such as Mrs. Starbucks for a period of 30 years from 24th June 2026 without any option of renewal for the purpose of this. This is below the possession certificate. And what I have been given is also indicated, my lord, in the possession certificate in that map. Now, my lord, pursuant to this, my lord, when I went to just clean up the space, my lord, I am faced with this problem. Kindly, my lord, now come straight to page 114.
Yes.
My lord, 114 million, your lordship will find on 6th of June 2026, the petitioner is writing to the estate manager of the port. Kindly come to the second paragraph of that letter, which starts with today. Today, on spot working in our areas for cleaning of garbage, washing in our property as well as the front side of it is unauthorized use for urine and latrine and other occupants. Also note that today around 11:30 am, the Department of Army Department, Gautam De, Maidan in charge, so as well as Railway Department, I see Mr. Govinda Prasad Bauri, BBD Bank, so and so, both the department obstruct in our plot at Chapalga. This situation will make it extremely difficult for us, rather impossible for good conduct of our business there. If we face such hindrance to begin with, it becomes a meaningless for us to venture into initiative therein taken at high cost. In view of the above, we request you to kindly take appropriate steps to make the property as well as NOC for both departments and other illegal occupants to hand over free from entire income and enable us to conduct smooth running of the business. There is no reply to this. Thereafter, Millard, there are representations made in the same lines. Now, Millard, the obstructions, Millard, are two Millard government arms of the government. They cannot physically obstruct somebody who is legally in possession of the property. If they want to initiate proceedings, they will do so in accordance with law. But they cannot come and obstruct, Millard, my possession or in enjoyment of the property which I have got in accordance with law, the documents which are before your lordship. But all I want today, Millard, subject to hearing all the parties, that my possession and working on the property should be protected. Rest, Millard, thereafter, if they want to use affidavits, whatever. This is, Millard, the short point.
Good eye, because the duty of the lessor to protect the interest of the lessor. But the property belongs to me, it has no doubt. Can you see the conveyance of 1874?
দিয়ে দেবো তো সব করি
Can you see, this is the indenture of 1874, where the port became the owner of this property. This is a conveyance. I did not travel also the entirety.
1884.
1874 at the top.
1874, yes.
Yes, it has never been divested, because unless there is a transfer on the conveyance on the TP Act, it cannot be divested. So today, my lord, we are the owner of the property. And previously, one document has been annexed by the lead petitioner. Kindly come to page 112. There was a previous unauthorized occupant in that property. By exercising power under the PP Act, who can exercise? My lord knows very well that if I am not the owner of the government property, I cannot exercise. I exercise my right under the PP Act, and other tenant was evicted from there. So today, my lord, it cannot be any shadow of doubt that we are the owner of the property and can exercise my right under the Act. By exercising that right, we have put it in. I can give, my lord is going back home, my lord, you can see, just after you come in the corridor, you also will find in the Ganges, on the Ganges, there is a petrol pump. Just beside that, this property.
Petrol pump is
my lord has seen that petrol pump is there, that belongs to us. Thereafter, immediately adjacent to that, there was a restaurant previously was there, one car showroom was there, this belongs to me. Here, my lord, Defense Authority has no right of ownership. Today, my lord, they interfere with the right of the port trust, that is, my lord, is not in accordance with law. That's why, my lord, what Mr. Doctor submitted, my lord, I totally adhere to his submission and say that we are the owner of the property, and the central government or the Defense Authority cannot do anything so far as the ownership is concerned.
It was initially given earlier.
You are appearing for?
Therefore,
1 to 10.
1 to 10 হতে পারে না। One তাই
ও বললে রিপ্লাই বলতে হয়, ও বুঝুন বললে যে রিপ্লাই বলতে হয়।
Defense authority.
রিপ্লাই বলতে হবে, যদি বলে রিপ্লাই বলবে।
হ্যাঁ।
Page number 5, paragraph number 4. That the respondent of 4 to 7 represent the Union of India and the local defense military authority having discretion over the area in which the subject plot is situated and are likewise stayed within the meaning of Constitution.
ঠিক আছে, ঠিক আছে, বলুন না, ঠিক আছে, অসুবিধা কি আছে?
Lordship, this is the under the blue zone. We cannot allow
আসবেই না।
It makes the property of the portal. Portal gives so many property to several illegal occupiers there. But this is under the blue zone. There are 3 zones, A, B, C. A zone is the 40 years. B is the this zone or
Show the your map or record that this area belongs to you.
I am having.
So how I can tell
Please. You show me that this area belongs to you. Okay, then I am staying on you. Stay your hand not to disturb the possession. His person.
And enjoyment.
By making any construction. Because
Why?
This is the main.
It's a commercial. When the tender notice was published.
25, in 25.
Just
in 25 tender.
That's why when the tender notice was, please hear me first, or you argue the first, then I will give the answer to you. Choice is yours. Which choice? First you argue. Then I will put the question to you. First of all, you have to place the record this land property belongs to you. One thing. Second thing, you have to show this is not the hide and seek game. It is the e-tender notice was published. Where is the objection raised by you that you cannot lease out the property? This property belongs to you. Show me that.
Sometimes because
Tender is 2025 as of today, no objection.
What your record says?
That is exactly what I wanted. Protect me, don't allow me to it is possessed without due process.
Really also involved. Railway department
Which?
in this matter.
Railway is nothing to do.
Railway
is nothing to do.
Railway track is causing, that's a
Railway wants that iron.
You are for the Union of India. You come with all.
Can also appear for railway.
No. At this time, I'm not happy for this. Don't give some.
Okay, not to disturb by that time. Why you are disturbing?
Order. I think that let me to place all evidence before working.
What construction?
No.
There may be four there.
I have the tender was for using it for commercial purpose.
Correct.
And I have not only got the successful tender in respect.
Naturally, they have to, because they have taken the premises by way of tender. You have not objected for the tender. No. Wow. In their application, you will get a stay.
1,30 lakhs has been paid by me upfront for 1 year's rent.
In your application, how you can prefer? You are not challenge. You have not come challenging the tender. Huh? Okay. Till that you stay your hand not to disturb the possession.
Sorry? This pendants is there. This pendants is there.
That's what I was going to say. Anything that will happen.
Remove it.
This is not the, heading now is filing, for
By Maruti to come and inspect it any day.
The petitioner has filed the presented application being agreed and dissatisfied of the respondents number 4 to 7. Yes, 4 to 7 and 5. 5. As the said authorities are not allowing the petitioner to execute their work in terms of the lease, in terms of the what work order,
Possession certificate.
in terms of the possession
The,
certificate as well as allotment letter issued by the port authorities to the petitioner. And counsel for the petitioner submit that the port authorities have issued the tender notice with regard to allotment of land at Chandpal Ghat at Strand Road, being plot number 136 by 25 within bracket A, on long-term lease for 30 years, comma, on as is where basis, without renewal option, against payment on annual rent, oblique upfront basis. The petitioner has participated in the said tender and found the it is and the possession was and found that and the petition was selected to be considered to hand over the said plot to the petitioner for a period of 30 years as is where basis without any option for renewal. Accordingly, on 15th of June 2026, a possession letter was given to the petitioner with respect to the said property. No, what is the page 96?
Millard, page 96 minute is the allotment letter.
Allotment. And on 24th of June 2026, the possession was handed over to the petition along with the sketch map of the property which has been allotted to the petitioner in terms of the tender notice. When the petitioner had started his work in the said area, comma,
that is at page
114, comma, the respondent number 4 to 7. The respondent's number 4 to 7 have restrained the petitioner to execute their work and stop the petitioner for doing their work in the said area. The petitioner has made representation to the respondent or the state officer on 6th of July 2026 and subsequently several representation has been made, but the respondent the port authority have not considered the representation submitted by the petition. The same is pending. He submits that unless and until the respondent number 4 to 7 are not restrained for disturbing the possession of the petition and allowing to execute his work, comma, the petition will suffer irreparable loss and injury. Land Council appearing for the port authority submits that the said land, the land which has been given on lease to the petitioner in terms of the tender notice, comma, this said property belongs to the port authority, and accordingly the same was leased out to the petitioner. The Landed Council for the port authorities also draw the attention of this court to the order passed by the
111.
Yes, passed by the learned Judge 7th bench, wherein the port authorities have initiated the case against the encroacher under the Public Premises Act, and the matter went up to the appeal, and it was held that the port authorities are the owner of the property and the eviction order passed by the authority was upheld. from the it submits that from the said order also it reveals that the port authorities are the owner of the property in question. Learned counsel appearing for the respondent number 427 submits that the respondent number 427 are also the why is it? Land belongs to you. 427 submit that the said land belongs to the defense authority, and the port authorities have illegally published the tender notice and given the possession of the said property to the petitioner. He submits that if at this stage any order is passed by restraining the authorities and allowing the petitioner to construct over the said property, the respondent number 427 will be prejudiced. Learned counsel for the state submit that has submitted the report. State has submitted the report wherein it is mentioned that the dispute between the parties was started over the issue of opposing the petitioner to open an authorized Maruti Suzuki showroom and workshop. He submit that the police authorities have nothing to do in the matter with regard to the property in question. Police heard the learned counsel for the respective parties produce the materials on record. The respondent authorities the port authorities have published the tender notice with respect for allotment of the land on lease for 30 years as is where basis. The petitioner has participated in the said tender and was declared was found eligible to offer the said landed property, and accordingly possession was handed over to the petitioner. The petitioner has deposited an amount of rupees
1 crore 24 lakhs
1,24
crore 26 lakhs 42,697.
ঠিক আছে? Being the annual rent.
Annual rent plus consideration plus GST plus whatever.
Submitted during the tender process. And the petitioner has to pay the annual rent in terms of the terms and conditions of the tender notice. Full stop. The petition full stop. This court find that full stop. The respondent number 427 claims that they are the owner of the property, but they have not produced any document before this court and press for time to produce the report and produce the document to show that the respondents number 427 are the owner of the property in question. Considering the above, this court find that the petitioner has made out a prima facie case and balance of convenience and inconvenience in favor of the petitioner. And as such, the respondents, particularly the respondent number 427, are restrained from interfering with the possession of the petitioner over the premises in question till 27th of August 2026. The respondents are directed to file affidavit in opposition within 2 weeks, within 3 weeks or 2 weeks. Reply if any they are to be filed within 2 weeks thereafter. So 4 weeks नहीं होगा ना, आज कितना लगेगा 28 है till 30th till 2nd September करो. Reply within 3 affidavit in opposition 3 weeks. Reply within 2 weeks. List the matter on 9th of September 2026. Interim order 9th September तक कर.
Possession and enjoyment in terms of the lease.
My one place that under the jurisdiction of the defense. Because they
submit that this property is
my lord, nobody has admitted this. Nobody has. No document, nothing has. I'm not saying they.
The
environment does to the Article 12.
Respondents, particular respondent 427, restrained from disturbing the possession of the petitioner and to making any construction over the property and for making any construction over the property in question. And for making any construction over the property in question.
I will not make.
Restrain.
You can carry on construction.
Yes, give the name. I recorded your submission.
Interim order continue till
9th September.
9th September.
Come on 9th September with the affidavit.
My lord, before your lordship takes up the original side matter, my lord, interim order is expiring today, my lord.
Matter. Lordship, I 21.
121, my lord. We are mentioning upon notice.
Where state government undertaking is writing in the government.
It is for the central government to withdraw that penalty which they are imposing. Otherwise, then we'll be happy to go home, my lord. I know when this was filed, it was different, my lord. Now it is.
State
What is the matter?
But this is regarding, my lord, penalty invocation by the central government for non-achieving of certain milestones in connection with the coal block which was allocated to West Bengal Power Development Corporation. But the petitioner is West Bengal Power Development Corporation.
Can you make one line after this?
Item number 121. Though the matter is listed as item number 121 of the today's list, but due to paucity of time, the matter could not be taken up for hearing. According counsel for the petition mentioned the matter and praised for extension of interim order. Then counsel appearing for the Union of India submit that this is a dispute between the state government and the central government.
State government undertaking and the
State government undertaking and the central government. This court is of the view that by the time the central government will take appropriate steps so that the matter can be resolved between us.
Grateful, I'm so grateful.
Interim order is extended till 21st of August 2026 or until further order that the matter remain in the list.
kindly will not observe that both the parties should take appropriate steps so that matter can be instead of central government.
It is in their hand, my lord. I can.
Both the parties.
So the dispute between this and the central government of the view, this court is of the view the both party shall take appropriate steps to settle the dispute.
Grateful, I'm so grateful.
Go and settle now. The central government is.
Well, we are always willing, my lord.
Indication to you.
Yes, my lord.
Next item number 14, my lord, regarding my lord, the Sabuni Mala permission. Sabuni Mala permission of the Sabuni Mala, which has been going to be held to my lord 31st July to 14th August. Since it is the
Who will give the permission?
Led by Mr. Chakraborty. This is a case, my lord, the petition, there are locus in the issue, my lord. The petitioner before a lordship is the secretary, not the Shomiti which has come forward. Secondly, my lord, it is it is for the public cause. So this cannot be, my lord, a humble submission cannot be considered to be adversarial one. And thirdly, my lord, so far the merits of the matter is concerned, my lord, there are several allegations made by several vendors that this Shomiti has extorted money from the vendors, allowing them to install to stalls and other things, my lord. For that, it has been denied. And fourth point, my lord, there are two reports I have received. One,
you do one thing, come tomorrow with the report. Come tomorrow with the report.
Reports I have received from the police. That's for the public law and order protection, nothing on the merit. And second, from the BDO, that it comes under the Pashkota municipality, which is not a party to the proceeding here.
BDO is not a party.
BDO,
whom you applied for the
municipality. Municipality is not a party.
Executive Engineer National Highway Authority is a competent authority. He has refused to give the party.
Who?
Executive Engineer National Highway Division.
How the executive engineer National Highway Division will give the, you wanted to conduct this program in the National Highway?
This is the land of the PWG roads. This is the land of the PWG roads. Earlier, last 11 years, they have granted the permission. Today, they have been asking for not to give the permission. I am the annexing all the permission which has been granted earlier, previously. Kindly come to page 18 onwards. Lastly, my lord, he was granted, my lord, the 27 July.
Who is appearing for this executing National Highway?
We're only appearing, my lord. So one of the issue is there are several allegations made against the Shomiti.
What
the allegation that they are extorting money from the vendors by allowing them to install the stalls and other things, my lord.
If it is that, then how?
They have been asked for that extorting the money. The earlier previous occasion, they have been not asked.
They have granted. Now there is an objection. Your vendors have given the report. Where is the report? You are having the report.
Report I have not written report.
I can come tomorrow. Come tomorrow with the report. Because 31st is the last day.
31st is the last day.
But then day after, let it be on day after.
Day after tomorrow is the 30th.
30th. My lord, it will start the 30th.
Come tomorrow. Come tomorrow.
What about Pashkura municipality? Huh?
Pashkura won't come.
It's pretty far, Malad.
Municipality is not
No,
required.
I'm sorry. Malad, the
NHA.
authority, yes. The authority made.
Executive engineer NHA. NHAs are having all the email and all these things.
Yes, they haven't. They only contacted me. This is to the public. Also.
Definitely.
It'll be easier for convenient for us.
Okay, come tomorrow. इसको ऐसे ही रहने दो ऊपर में. कल.
No, kindly keep the maintainability point of the expedition. But kindly keep the maintainability point of the expedition.
Tomorrow, I am not passing any orders. Come tomorrow.
The state will not any order.
The state will not order is necessary.
Actor record करो.
It's service record.
The read then.
And kindly direct filing of the report. Will kindly direct the filing of the report.
File दो. The petitioner has filed the present application praying for a direction upon the respondent number 6 and 7 for grant of permission for holding Sravani Mela Festival 2026 from 31st of July 2026 to 14th of August 2026. Learned Counsel appearing for the respondent authorities submit that there are allegations against the petitioner that the petitioner is taking money for allotment of
Allotment of
Proper rooms.
allotment of land, Malad.
Allotment of land.
PWD department.
Allotment of the land for the purpose of the Mela. Police to consider the submission made by the counsel for the parties. The respondent authority is directed to file the report by tomorrow. Please the matter tomorrow under the same meeting within 5 matters.
Deeply obliged.
Lordship, the next matter, may I?
Yes, call the original.
My lord, may I have your lordship's leave to mention an original side matter, my lord. My lord, my bank accounts have been frozen on the basis of a complaint issued by a director who resigned in 2017. I'm not able to operate bank accounts, not able to pay salary, not able to pay statutory dues, my lord.
And when it was closed?
It was frozen in June, my lord, 2026. I filed the writ petition immediately thereafter, my lord. If the no FIR, a resigned director of 2019 writes a letter to the bank and bank freezes my account. My lord.
See, the authority.
My lord, may consider.
Astral director is more powerful than your director, the present director.
My lord, may consider.
My lord, may I be permitted to mention one matter for?
Mention one matter, my lord.
155.
Matter was for Alfred was 6 for Alfred and time was 6. My lord, thereafter, my lord, resolution.
Resolution, then I will not allow.
9 June was 3.
If resolution, the case is adjourned, I will not allow.
No, I am not telling. 13 days for resolution also didn't appear. It was time was 6. Now the matter is appearing a very short matter. Argument, my lord. We have finished our argument.
Which matter? What is the matter?
The matter is money advance, my lord. 1 crore rupees advance is an associate factory of advance is money. Along with this, agreement was there, my lord. We have finished our argument, my lord. Now the matter is.
Who is for the other side?
I have given notice to the other side, my lord.
So what do you want?
I want any date.
September?
Today,
September.
Date and time.
7 September 3 p.m. Give that.
Yes. May I be permitted to mention one matter for non-prosecution?
Listed?
No, it is not.
Not listed. So to be mentioned, मैं कर दो, कल कर दो. Yes,
that may I be permitted to mention to draw up and complete an order dated 24th June 2026.
24th June 2026. Which order?
Lordship, this is that Pranava City Conflicts versus Gyan Traders, that circular transaction. We, on behalf of the plaintiff, have filed a judgment on admission.
Grant kar.
Grateful, Lordship.
The matter, my lord. With, item number 17 in today's list, expiry of interim order, my lord.
Today?
Lordship,
item number?
Item number 17 is today's list, my lord.
Lordship, if you remember, on the last occasion, Mr. Shashwata Nayak had completed his arguments.
Order.
Mr. Rajoshi Datta was supposed to, on behalf of the petitioner, he was supposed to rejoin in this matter. On the point of maintainability, Mr. Shashwata Nayak, yes, Your Lordship, had.
Order last.
Today the matter was fixed, but since it's at serial number 70, it may not reach.
May not reach.
Lordship may fix it on any day.
Though the matter is specifically is fixed today for as item number 17, but due to paucity of time, matter could not be taken up for hearing. And counsel for the petition mentioned the matter and submitted the interim order still today and prayed for extension of interim order. In view of the submission made by the learned counsel for the respondent submit that the respondents have already argued the matter and only the petition has to give a reply. In view of the submission made by the counsel for the respective parties, the interim order extended till 19th of August 2026 or until further order, whichever is available, let the matter remain in the list.
Time fix, my lord.
Lordship may kindly fix it.
And then it will go to August, September. That's why let it be recorded. If fixed matter is not taken, I will call the matter. No problem.
19th August, Lordship.
No, till the 19th, matter will remain in the list.
Lordship.
Yes, next.
Lordship, once again, the matter was fixed on 17th, but due to some case, it couldn't be taken up. And now it's running on the list number 138, today's list. Could you just fix it anytime next month? Anytime, fix a day, fixed date. Some 3:30, 3:45. Much order. 26.
Yes, call the list.
But I appear for the petitioners along with Mr. Thakur and Mr. Nodia.
Considering taking into consideration of the above facts that the petitioner have not claimed the benefit of the terms of framework even after the demand notice under section 13(2) of the Surface Act 2002 and was issued, and the bank has taken the symbolic possession of the properties and also at the flag, and the petitioner has filed the present application for praying for the benefit of the framework. This could find that the petitioner cannot claim the benefit at the flag end of the same. Accordingly, the petition is dismissed.
Item number 3. If your lordship recollect, this is that Parsi trust matter.
Yes.
Lordship, I appear for the there was a direction for filing the
You are appearing
for the intervener referee, Lord. So if I may file the report, Lord.
That Mr. Zaiwala, your lordship was pleased to appoint him as a special officer because he was resisting, my lord, the prayer. So may I just say this, my lord? Your lordship, they have filed a report. Lordship kindly keeps it as to be mentioned tomorrow. We'll consider the report, come back if you, my lord, it can be disposed of.
It's been served. Just one higher bid has come in, Lordship.
No problem.
Keeps it as to be mentioned tomorrow, my lord, it can be disposed of.
Let the court see what is the report. Yes.
Your Lordship will kindly take the offer at page 13, Lordship.
1-3.
Yes, Lordship.
6 crore 12,000.
12 lakhs, Lordship.
6 crore 12 lakhs.
Yes, Lordship. That's the bid that has come in greater than 6 lakhs.
Who is Rohra? developers.
Yeah, sure,
Okay.
sure.
So I am fixing
Yes,
for
sir.
acceptance
Yes, sir. It can be fixed.
tomorrow or day after.
Tomorrow, Lordship, tomorrow, day after, any day convenient to your Lordship, It may appear as to be mentioned, my Lord, we'll just, your Lordship can dispose it.
Intervener has filed the report after serving the copy to the council for the.
May I request this matter to be taken up day after? Because of that.
Very. My Lord, my junior has, my Lord, suffered a bereavement in his family. He's lost his mother. So he
This-
has his last rites. So kindly keep it day after, my Lord.
This is the matter on 30th July under the heading to be mentioned.
Grateful.
Oh, your lordship, I appear on behalf of the receiver, the special officer who was appointed by your lordship. By your lordship's last order, 23rd was filing the report. We've circulated the report on the 23rd. I'm only playing that the time be extended and the report be taken on record. This is that matter where 2 years back the visit was carried out, which is why we had to.
There's no further, the petition was, the application was not for direction upon him to file the report. There's no other prayer in the application. Your lordship may dispose it off with liberty to the petitioner to apply, because there are certain directions on the report of the receiver for which we will have to take separate steps. So kindly take the receiver's report on record and dispose of the application with liberty to take appropriate steps in accordance with law.
Why? What is the report? By which order?
Your lordship will kindly once take up internal page number 6 onwards. Your lordship, the observations have been, your lordship, with respect to inventory and other aspects of the visit have been enumerated. 20, your lordship, with respect to the implementation of your lordship's order dated 31st January 2024. The necessary directions that may be passed, your lordship, that is also enumerated. The other aspect, your lordship, my learned senior Mr. Sinha is taking care of it.
He could comply with the directions, in part, some part he could not comply with. He has given reasons why he couldn't comply with. So we'll have to take steps to seek appropriate directions in a proper application. This is not main section 9 has been disposed of. So I'll have to file a fresh application with regard to implementation or giving further effect.
The special officer appointed by this court has filed report after serving copy to the learned counsel for the parties. Let the same be kept with the record. Solicitor learned counsel for the petition submitted that the special officer has submitted the report wherein it reveals that some part of the order has been complied with, and with regard to the other part, the petition will take appropriate steps in accordance with law.
Your lordship, I apologize, your lordship, just one more aspect beyond the brief, if I may just request, on instructions. Your lordship, I'm told that the special officer was awarded a sum of given a sum of rupees 3 lakhs as initial remuneration. If some subsequent remuneration could be.
In accordance with law. Full stop. Yes, Mr. Sinha, what about the remuneration?
He had visited once, and a remuneration of 3 lakhs was fixed by my lord, which has been paid. I leave it to your lordship, whatever your lordship deems.
It is submitted by the petitioner that the initial remuneration fixed by the petitioner is paid by the petitioner to the special officer according full stop as the special officer submitted the report and the same is accepted. Accordingly, the petition directed to pay further amount of rupees 50,000 to the special officer with a from date. In view of the above.
This has come up for correction because on 24th of July, in some other matter, my lord, an order was meant to be passed, but it has gone down in the wrong cause title. Fixing the matter on 2nd September at 3 p.m.
But upload हुआ है ऑर्डर यही था नहीं ऑर्डर यही था लेकिन कॉन्स्टेंट में गलत है ना ऑर्डर वही तो ये नहीं, लेकिन इसमें यही ऑर्डर होना था, लेकिन इसमें वो कॉस्ट चेंज हो गया। The matter is listed as to be mentioned for correction in the order dated 24th of July 2026. Land Council for the petitioner submit that on 24th of July 2026, item number 13 was WPO 12255 of 2023 within bracket Messrs. D. Das and Brothers and another versus the Secretary, Land and Reforms and Refugee Reliefs and Rehabilitation Department, Government of West Bengal and others. But in the order dated 24th of July 2026, the cost title and the number of the WPO was wrongly recorded as WPO 11 of 2026 within bracket Deal Unique Realtors Private Limited and others versus Reserve Bank of India and others.
My lord, in this matter, I am appearing for respondent number 2, Yes Bank of India, not the petitioner. Perhaps it has gone down as.
I am for the petition. I have the same.
In view of the above, this court find that the order has in the order dated in 24th of July 2026 inadvertently recorded in WPO number 11 of 2026. Accordingly, the order is recalled. Order dated 24th of July 2026 passed in WPA number 11 of 2026 within bracket Deal Unique Realtors versus is recalled. Full stop. Full stop. The full stop. As per the prayer made by the council for the parties, let the matter appear on 2nd September 2026 at 3 p.m.
No, my lord, this was not supposed
this
to
matter?
be fixed at. This was not supposed to be fixed. On the contrary, my submission is this has become infructuous. So, but
So what will happen? No order was passed in that day.
no order was passed on that day.
Yes.
No order was passed.
It's hereby record, huh?
My lord, I have only one prayer to make before your lordship. Let item number 16 and 20 up to 16 to 23 be clubbed together and be put fairly at the top so that we can have it heard out and thrashed out, because these are all at different stages. They have come up on writ, challenging the proceeding, challenging the steps taken by the bank in order of declaring their account as a willful defaulter and fraud. Now, with regard to the willful defaulter, they have participated in the proceeding. Everything has happened. If anything, everything has merged in that. Whatever order is going to be passed, they'll have a fresh cause of action. So let this matter be kept as to be mentioned or something. Let my learned friend also come up, because I am led by Mr. Bose in the matter.
Who is appearing?
For me, Mr. Jishnu Shah is appearing for the petition.
For the bank.
I'm for the bank.
So what will happen if it is fixed for the to be mentioned?
Because they can come up, because on instruction they can come and say whether they are pressing this, because any which way nothing remains.
On the last occasion, my lord, I had prayed for time to file supplementary affidavit.
Nothing has come on board.
Yes, I'll make my submission. Just to bring on record the documents. That document is ready. My client was not available. That's why I could not file. My lord, may keep it in the next week. I'll just file that. I'll serve it on advance on them today or tomorrow. And it can be taken up in the next week and disposed of, because I have participated pursuant to directions passed by this court.
He's also submitting the same thing.
Okay. I have participated.
They have participated in the hearing, although in law we are not entitled.
You have to wait for the final
order.
Yes.
Whenever
if the final order is
That
not,
will
then
be
you
a
have to
fresh cause of action.
All
Yes,
points can be kept open, my lord.
Yes.
Naturally.
Let them find it out.
Item number 18. No. Item number 18.
16 to 23.
16 to
22, your lordship.
22.
16 to 22.
16 to 22. Friday को रख दो to be mentioned में.
My lord, may I pray next week, my lord?
Next week.
Any day in the next week is convenient to them.
Then एक काम करो 5 तारीख को रखो 5 अगस्त.
Any day.
5th August as to be mentioned. Yes, call the list.
Item number 6.
Your lordship, please, and for the petitioner.
Malad, I'm appearing for the respondent number 4, Malad, through VC, Malad.
May I hand over the evidence service? Before I proceed with the matter,
For the respondent state.
I want to make myself correct. There is certain mistake in cost title. And the cost title, it is inadvertently written as within jurisdiction. It is required to be corrected. It is outside jurisdiction, but I am working for gain within jurisdiction. So, leave the granted letter, I will make it correct.
Which paragraph?
copy to my.
Which paragraph?
Cost title.
First title of the petitioner.
Petitioner. Page
3.
Page 3.
Okay. Yes. What is the matter about?
This matter pertains to Judicial Service of Consumer Affairs Department. I want to proceed with the matter in twofold ground. First, I will argue for seeking order in personam.
You are the person in person?
No, in person, not in person. In personam, ordered in personam, and later on I
Order in
will also
personam.
argue seeking His Lordship kind intervention into this matter by pronouncing judgment in rem for greater public interest. Though I don't have any specific prayer in my writ petition, but for public
If you,
at
if you
large,
want,
for the
the,
interest
if you
of
want
public
the order in the greater public interest, then you have to go to the division bench. Before the court number
His
1.
Lordship can pass when there I can satisfy His Lordship. Moot question involved in this matter. If there is a clear disobedience of the solemn direction of the Honorable Supreme Court of India, passed in rem, then is it violative of the provision of Article 144 of the Constitution of India or not? If other states, second issue, if other states are following the direction, and if my state denies me, then is it amounts to denial of my right of equality guaranteed under the Constitution of India under Article 14 and 16. My lord, I was appointed, I am a retired IS officer, also a law graduate. After my retirement, I was appointed as a member of State Consumer Redressal Commission at Calcutta as a non-judicial member. Now I am serving as a non-judicial presiding member of Bench 3 of State Commission. My lord, kindly come to Annexure 1 at page 32. This is my appointment letter notification. That is 1st August 2022. Man. In exercise of power conferred by Rule 6 of the Consumer Protection Qualification for Appointment, Method of Recruitment, Procedure of Appointment, Term of Office, Resignation and Removal of the President and Members of the State Commission and District Commission Rules 2020. The Governor is pleased to appoint so-and-so as member State Commission, State Consumer Dispute Redressal Commission, West Bengal. The appointment so-and-so. Now, my lord, kindly come to the next paragraph. Governor is pleased to direct in terms of Rule 10 of the Consumer Protection so-and-so Rule 2020. She will hold the office for a term of 4 years and up to the age of 65 years, whichever is earlier. And kindly, last paragraph. This appointment is made in the interest of public service. Next page, kindly come. Is a corrigendum. My name was corrected. Instead of Soma Bhattacharya Basu, it will be Srimati Soma Bhattacharya.
So now what is the grievance? What is the grievance?
In the meanwhile, my lord, my lord, kindly come to the Rule 6. There is an amendment in Rule 6.
Tell me, please, your grievance. What is your grievance?
Grievance is, there is a Supreme Court direction giving extension of all the appointment till new rules come forward. Disobeying that Supreme Court direction, I have been given notice to hand over the charge by 31st of July.
That is 4 years. Achha, 31st
Yes,
of August.
4 years. It is going to elapse. I want to place Rule 6 and 10. Yes. এটা না আরেকটা বই আছে দাও দুটি ওখানে আরেকটা বই দাও। I'm placing the previous rule at the time of my appointment. My lord, rule 6. Kindly come to rule 6.1. The president and member of the state commission and district commission shall be appointed by the state government on the recommendation of the selection committee consisting of following persons, namely Chief Justice of High Courts, so and so, so and so, so and so. Now, my lord, kindly come to sub-rule 9. Selection committee shall determine its procedure making recommendation keeping in view of the requirement of state commission, district commission after taking into account the suitability records of past performance, integrity and dedicatory experience. Now, my lord, kindly come to rule 10, term of the office. President, every member of the state commission and the district commission shall hold office for a term of 4 years or up to the age of 65 years, whichever is earlier, and shall be eligible for reappointment for another term of 4 years, subject to the age limit of 65 years, and such appointment is made on the basis of recommendation of the selection committee. Subsequently, yes, this rule has been amended. Initially, rule 6.9 was amended in the year 2022, and in the year 2023, rule 10 has been amended. Yes. I'm coming into the rule amended in the year 2022. May I hand over the book? Yes, yes. Kindly have a look into the notification of 2000 amended notification. In terms of office, rule 2, every member of state commission, president of every member of the district commission shall hold office for the term of 4 years up to the age of 6 years, whichever is earlier, and shall be eligible reappointment 4 years, and so and so. Earlier it was one sub-rule, there was no sub-rule. Now, my right accrued under sub-rule 2. Now, Your Honor, kindly come to the rule, amended rule of 2023.
So 22, there is nothing.
23, another amendment. In respect of
there is nothing.
In respect of sub-rule 9. Another amendment. Now, my lord, kindly come to the Supreme Court judgment.
Where is the 23? What the 23 says?
20, I have already handed over.
What the 23 rule says?
So, rule 6, sub-rule 9 was amended. 23rd. Rule 6, sub-rule 9, selection process has been made.
Yes.
Selection committee shall shortlist the appointment on the basis of performance in the written stage.
So that is set
consisting
aside.
of 2 papers, so and so, so and so.
This set aside.
At the time of my appointment, I was not subjected to any written test
Correct.
or viva.
Yes.
Then, now I want to proceed with the Supreme Court decision. Well, kindly come to judgment 1. I am also making over a copy to my learned friend. State Secretary of the Union of India. Judgment 1. My lord. J1. 2025, volume 8, SCC 634. Kindly come to paragraph 13 at page 15.
Page?
Page 15. Paragraph 13, may I? Therefore, consumer litigation is a form of public interest litigation, which builds an active citizenry, enhancing participatory democracy. Participatory democracy is one of the basic features of the Constitution. The principle of participation in the governance of the country is not only a constitutional right, but also a human right. It is thus imperative that consumer litigation should be allowed to go multifold for a democracy to flourish. Now, my lord, kindly come to page 29 at paragraph 43. First three lines. Thus, the court was pleased to hold that it would only be just and fair to ensure uniformity in way of common set of rules applicable to the consumer fora in all the states. Then, my lord, kindly come to page 33, paragraph 49. Striking down the Rule 6 and Rule 10. Yes. The decision rendered by the division bench of the High Court of Bombay was challenged before this court in Secretary Ministry of Consumer Affairs versus Dr. Mahindra Bhaskar Limaye and others, 2023 SCC Online, SC 231, herein after referred to as Limaye 1. By judgment, it is so and so, it was held that the requirement of 20 years and 15 years experience for eligibility of a non-judicial member of the state commission and the member of the district commission respectively was arbitrary, and then 10 years experience is sufficient. It was also held that Rule 6(9) of the 2020 rules, which confer unfettered and unbreakable powers on the selection committee without the mandate of conducting written examination followed by viva voce, cannot be sustained in the eye of law. Then, my lord, kindly come to bottom two lines. Suggestion had been given on the manner in which written examination followed by viva voce was to be conducted. Then, my lord, kindly come to page 41, paragraph 55. The High Court of Bombay, by judgment, it is so and so, impugned order, impugned before us in civil appeal number so and so, so and so, so and so, has partly allowed the writ petition and struck down Rule 6(1) and 10(2) of the Rule 2020 rules, finding them to be legally unsustainable, and has also quashed the notification and advertisement insofar as paper 2 is concerned. Then, my lord, kindly come to page 54, paragraph 72.
Sir, what is your grievance? You want that where is the Supreme Court direction? They may continue unless the rule
Well,
is
in this judgment,
show me that only.
Rule has been struck down.
So, where is that?
And union, the central government has proposed to bring a new rule.
Show me the judgment of the Supreme Court, which portion?
Yes, my lord. Page 72, Union of India proposed to amend the Rule 2022, amended in 2023 as follows. My lord, 72. And page 62, Supreme Court confirms striking down of page 62, paragraph 83. Honorable Supreme Court confirm the striking down of Rule 6(1) and Rule 10(2). Yes. Then the operative portion, I'm coming. Kindly come to page 102, it's a directions. Page 81, paragraph 102.
Yes.
Subparagraph 2. In view of the submission made on behalf of the Union of India, we direct the Union of India to notify the new rules within a period of 4 months from the date of this judgment, strictly adhering to the following so and so, so and so, so and so. Then kindly come to page 84, subparagraph 4. As regards the status of appointment, this is important paragraph, operative part. The post of the presidents and members of the state and district commission, we are pleased to issue the following directions. 1 and 2 not related to me. I am related with 3 at page 86. 3. Presidents and members of the state and district commission who have been appointed and serving prior to Limai 1, prior to 2023. They shall be allowed to complete their tenure in entirety in the event.
In the year 2025, 15th of October, one execution application in a file before the Supreme. And
that I will come. That
is pending.
That has been rejected. No, rejected.
For a moment, last two paragraphs.
That has been rejected. That has been rejected. Review rejected. Review rejected. 2015 আরেকটা judgment আছে দেখাও। এটা কত ডেট আছে?
2025, 5 and 25.
ওটা একটা রিজেক্ট হয়েছে একটা। রিভিউ একটা রিজেক্ট হয়েছে। জানুয়ারি 2016 আমার অর্ডার আছে। 2026 সরি। আছে সুপ্রিম কোর্ট।
Yes, what is there?
Review rejected. Review rejected.
Rejected.
So far as I have a subsequent judgment, 2026 judgment.
So whether this order has been revived? The page 86 which he is relying upon, that the order is revived?
No. I have 2026 judgment also. Next judgment 2026.
Yes.
My lord, may I? In the event that tenure ending before completion of the recruitment process under new rules to be notified, their appointment shall be allowed to continue until the completion of such recruitment process, irrespective of the age limit. Now, my lord, kindly come to next page. 5 is also pertains to me. 5 is also pertains to me. 5. Next page. 5. Direction number 5. Person who are selected to the post of non-judicial members of the state commission and members of the district commission without having undergone a written examination followed by viva voce. This is same. If already appointed serving, in case of selection process completed prior to the decision of this court in Lemai Supra 1, such person shall be entitled to complete the tenure in entirety in the event the tenure ending before the complete recruitment process under the new rule to be notified, their appointment shall be allowed to be continued until completion of such recruitment process. Now, my lord, kindly come to next judgment of the Honorable Supreme Court passed in the year January 2026, J2.
My lord, if I may intervene for a moment, my lord, may I kindly read the paragraph, my lords, after the chart of this judgment which my learned friend was showing, my lords. The second last paragraph of the judgment. My lords, otherwise we'll have to come back to this judgment. But we make it clear that for all those appointments which have been allowed to continue within this judgment, the tenure shall be for a period of 4 years. Such persons shall not be entitled to claim the benefit of this judgment cover 5-year tenure. Subject to the directions issued herein above, we also make it clear that this judgment shall apply prospectively except to the extent indicated in the directions herein above. But the 4-year tenure, my lord, for the petitioner is coming to an end, my lord. That for that, I've just shown that paragraph, my lord. I'll make my submission thereafter.
It is clear this judgment shall apply prospectively.
Yes. prospectively. So 2025. So your tenure is 4 years. Yes. So what the prospectively give the benefit to you?
Prospectively.
What the prospectively give the benefit to you?
Because
Your 4 years has been completed. You
Yes.
show me the law that you can work for the more than
kindly come
after
to
the
the
65 years.
next judgment of Supreme Court.
See, if I find that you're not married, then cost will be imposed.
Yes.
You are wasting the time of the court. Cost will be imposed because other matters I am not taking. If this court find that your matter is not on merit, then
Obviously, I will try to
make sure the cost.
The poor advocate should get the cost.
This appeal has been filed against an interim order that is also passed by the High Court of Judicature Rajasthan, declining interim protection to the appellant to continue as a member judicial of the State Consumer Dispute Redressal Commission, notwithstanding the judgment of this court in Ganesh Kumar Rajeshwar Rao Shukla versus Vansasansu 2025 SCC online SC 1193. After hearing the learned counsel of the parties, as an interim measure, we deem fit it appropriate to direct that the applicant be re-employed as a member judicial of the State Consumer Dispute Redressal Commission forthwith order accordingly. It is further clarified the appellant upon reappointment shall be deemed to be continued uninterruptedly with effect from 1st December 2025 till the fresh recruitment is made and the rules are suitably amended by the state government in consultation with the High Court.
The member of judicial, what was the age?
Okay. 64. My age is now 64.
He wants 1 year service. Question is,
In 2027, I'm going to.
he is saying many things, but he approached
Now,
the
my lord.
Supreme Court initially,
My lord.
last P5.
Yes. I am now citing others court judgment, J3. Paragraph 3, the interim order, Urmila, Bharma, Swansha, Rajasthan, Swansha, and so it has been relied upon. I am coming to the, kindly come to paragraph 6, last page. Since the tenure of the president and member of the State Consumer District Commission, page 6, para 6.
Yes.
Since the tenure of the president/members of the State Commission, District Consumer Commission in the state of Rajasthan is coming to an end and has ended, but no fresh appointment has been made so far. Therefore, we deem it appropriate to allow all the officers to continue on the post they were holding uninterruptedly till fresh recruitment is made after the rules are suitably amended. Officers who have been relieved shall be re-employed forthwith, and those who are in process of being relieved, they shall not be relieved until further orders. Then Madhya Pradesh High Court, my lord, irrespective of the age limit, page 2, para 6. In view of the same, I find that it will leave no disruption of delivery of justice if there is no leave to disruption of delivery of justice if there are no members and presidents in consumer fora till notification of new rules. Therefore, petition is disposed of directing the members presidents shall be permitted to continue on their post even after their retirement or completion of tenure till new rules are notified, appointed, are made accordingly. Then next judgment, it is Madras High Court. Kindly come to page 12, para 5. Age limit has been discussed. In response to London Advocate General on instruction submitted, the state is of the view that presidents and members of the district commission who have reached The upper age limit of 65 years cannot be allowed to be continued in the post beyond 65 years. Appropriate action would be taken after the outcome of the writ appeals to be filed against the order passed in various writ petitions by coordinating bench of this court. He also placed before this court a copy of the written instruction received from the respondent number 1, para 6. This court, having taken note of the stand of the state, is unable to accept the state's stand as the above referred decision of the Honorable Apex Court is binding on the state, and the state is bound to give effect to the said order. It is not as if the state is unaware of the said decision, which was passed as early as on 21st May 2025. As absolutely no step has been taken by the state to give effect to the decision of the Honorable Apex Court. Learned Additional Advocate General also could not dispute the binding nature of the decision of the Honorable Apex Court. In these circumstances, the respondent is directed to forthwith take all necessary steps for giving full effect to the decision of the Honorable Apex Court in Swanson's case and issue appropriate orders enabling all the presidents, judgment is in rem, all the presidents and members of the commission and district commission within the state who are in service as on 21st May 2025 to officiate in their respective posts till the recruitment process is completed under new rules to be notified by the Union of India. The first respondent is directed to comply with the order expeditiously as possible, at any rate, within the period of 6 months, 6 weeks from the date of receipt of this copy of the order. The last judgment is, it was passed in the year 2024. Paragraph 4, kindly come to. Middle, 5th line, page 2, paragraph 4, J6.
Yes.
J6.
Paragraph?
Page 2, paragraph 4. This is prior to paragraph 4, 5th line from the top. Therefore, if the president's or the members' terms are going to end, it will create a vacuum in the state commission as well as district commission, which will go against the very object of the act and the rules. Then, my lord, kindly come to paragraph 5. Learned special government pleader appearing for the respondent submits that a press notification is in the pipeline and very soon the same will be published and new incumbent will be selected an appointment in respective post. Where there are vacancies which having already arisen or which are going to be arise in the near future, if president and district commission, state commission is allowed to vacate his office today, there will be only 2 members left, as other members, though whose terms are also expired, will stall the very functioning of the state commission. Then after the secretary and Dr. Mahindra Bhaskar Limai case were relied upon, then direction was given, paragraph 7, to continue with that. My lord, in this juncture, I have been served with a notice. Petitioner copy. I have been served with a notice to hand over the charge. Kindly come to paragraph. I made 2 representations that was not considered. Page 40. Second paragraph, last paragraph. Undersigned is further directed to request him to kindly hand over the charge to President so. Sorry, the undersigned is directed to say the tenure of service Home so has going to be complete on 31st July 2026 and requested to hand over the charge. I made an application before the Honorable Apex Court. This is, next page is an Honorable Apex Court order.
Yes.
Though we are not inclined to entertain this writ petition as the issue pertains to the State Consumer Dispute Redressal Commission and not a general tribunal or commission, liberty is granted to the public spirited persons to approach the Judicial High Court for issuance of appropriate direction for appointment of members of the State Consumer Dispute Redressal Commission.
Yes.
So, in personam, the judgment, as I refer in the year 2025, having its prospective effect. Even other judgments of the other High Court, they are also allowing. Even they have.
Yes, any further submission?
My lord?
Any further submission?
Well, I have.
Yes, what submission? Tell me.
Then 60, even elapse of the 65 years, I will
Yes,
be
who is
allowed
for
to
the
be
state?
reappointed.
Who is for the state?
No, I'm for the
Yes.
state. Well, the appointment is very clear that either 4 years or 65, either of the two. This petitioner has reached 4 years of service.
No, but what about the Supreme Court judgment and the considering the other
I
Court judgments?
am saying, Lord, it is in their application. They have said, my Lord, page 14 of the application, writ application. The Supreme Court says we make it clear that, my Lord, page 14 of the writ application.
Yes.
We make last paragraph. We make it clear that for all those appointments which have been allowed to continue by this judgment, the tenure shall be a period of 4 years. Such persons shall not be entitled to claim the benefit of this judgment, a 5-year tenure. So under no circumstances, the Supreme Court is categorical that 4 years continuity of service shall not exceed to 5 years. And my learned friend is showing different judgments. His basic argument is that I am to complete the. He has reached both 65 years and 4 years. Why I am telling your lordship? Lordship, kindly come to page 40.
Page
40. You have stated
the direction.
You have stated so long, and now you allow me.
Page 40.
Yes, page 40.
Yes.
The undersigned is directed to say that the tenure of service of Srimati Shoma Bhattacharya, member West Bengal such and such of State Consumer Redressal Commission, is going to complete. It should be is going to has been completed on shall be completed on 31st of July 26. Now, Lordship, 31st of July, she will complete his tenure. Now, Lordship, kindly see the representation made by the petitioner.
No, but what about the yes, continue.
Yes. My Lord, the question is, my Lord, that in the meantime, Lord, the recruitment process has been started. And as usual, one application WPO 204 of 2026 is pending. My Lord, it is my instruction.
Where it is pending?
Before this honorable court. It is pertinent that, yes.
Without framing new.
Yes, please. Has
take your seat.
It is pertinent to mention here that the department has conducted 2 consecutive examinations for filling up the vacant post in the year 2025. But due to pendency of WPO 204 of 2026, Anjali Chaturvedi versus Consumer Affairs Department.
Where from you are reading?
Therein, my lord, this is my instruction, my lord. Therein, the petitioner challenged the power of conducting examination for filling up the post. Due to pendency of this case, advertisement could not be issued for filling up vacancies. So that is the only reason.
No, new rule was framed. New rule is framed in terms of the order of the Supreme Court.
No, not yet.
So that you challenge, that is the earlier rule.
Yes.
That has been infactuous. That has become infactuous in terms of the order passed by the Supreme Court in the Lingmaya case.
Yes.
Correct.
Yes.
Now the Supreme Court has passed an order to frame a rule within 4 weeks and to pass to take
My lord.
appropriate steps. But the 4 weeks they have filed the review application, whatever it is, and the court has given the direction. Can
Yes.
you come to the J2, the second order passed by the Honorable Supreme Court,
The judgment.
19th of January 2026. J2 judgment which they have annexed.
Yes.
এটা দেখি।
Notwithstanding the judgment of this court of Gyaneshwar Shukla, after hearing the parties, so what will happen to that? And the other court is following this judgment.
The rules are to be suitably amended by the state government.
No,
It
kindly
will be
see
by
the
union
J2.
in para
First of
4.
all, first you have to satisfy this court. If the state government has framed the rule in terms of the Supreme Court order,
Yes.
it is there or not. If it is framed, so whether new incumbent has been appointed or not. If it is not, then the J2 order will remain
enforced. So, my lord, for that, my lordship, kindly give me some time.
31st is the last date. She will be out on 31st. Today we are on 28, 29.
If I may, my lords. My lord, the rules are to be notified by the Union of India, my lord. I am representing the respondent number 4 union.
You are appearing for whom?
My lord, for the respondent number 4 Union of India, my lord, on
Have you-
instruction. No, my lord, the rules have not been notified. They have not been framed, my lords. Because, my lord, we have given an affidavit in the Supreme Court as per instructions, my lord, that we've given an affidavit that is not possible for us to make the new rules. We've given that affidavit in the Supreme Court, my lord. The matter is sub judice, my lord. Then miscellaneous application has also been filed. So,
So,
my lord,
sir-
that is my instructions, my lord.
We have considered the Urmila Verma case.
No,
Urmila
my
Verma.
lord, J2, my lord, I have not, my lord, was handed over right now, my lord, I'm not aware. My lord, as per my instructions, my lord, I'm saying, and I leave it to your lordship, my lord, because other high courts are following the Supreme Court. My lord,
Correct.
my lord, but one difficulty, my lord, I have seen Delhi High Court and Madhya Pradesh High Court, my lord, I had it myself. They have not considered that paragraph after the chart, my lord. I'm not aware of the 2026 Supreme Court order, my lord. If there is a direction, my lord, it has to be passed, my lord. We cannot come in the way.
Because the January 2026, 19 January 2026, the Honorable Supreme Court has stated, notwithstanding the judgment of this court of Gyaneshwar Rajeshwar Rao.
Yes, my lord, if that is there, my lord, nothing, my lord, we cannot come in the way at all.
If the rule is not framed, then.
My lord, there are no rules, my lord, as per instruction, no rules notified by the Union of India, my lord.
So, when Union of India is affirming that, my lord,
For having no quorum, most of the benches are lying vacant.
My lord, because Union has given an affidavit, my lord, because the process, my lord, it's not feasible to have one process, recruitment process, my lord. As and when Supreme Court decides, my lord, then, my lord, till then, whatever order, my lord, has to pass.
Okay. Yes. So,
nothing has been done, my lord.
As it is required to represent the new proof.
The petitioner has filed the present date application challenging.
Sure. Rule framing on.
Challenging notice dated 24th of June 2026, wherein the Special Secretary to the Government of West Bengal requested the petitioner to hand over the charge to the President, West Bengal State Consumers District Forum Commission as she is going to complete her tenure on 31st of July 2026 as per rules. Police. Now, counsel for the petitioner draw the attention, submit that in the case of Gyaneshwar Kumar Rajeshwar Rao Suleka and others versus Mahendra Bhaskar Limai and others, reported in 2025 volume 8 SCC 634. The Honorable Supreme Court
সেটাই তো প্রথমে বলতে পারতেন, সেটাই তো প্রথমে বলতে রুল ফ্রেম হয় তো সেটা বললেই তো আপনি তো সেই একটা লাইন বললেই তো এতক্ষণ আর বলতেই হতো না আপনাকে।
held that the President and members of the State and District Commission who have been appointed and serving prior to Limaye within bracket Supra, they shall be allowed to continue and they shall allowed to complete their tenure in entirety. In the event their tenure ending before the completion of the recruitment process under the new rules to be notified, their appointment shall be allowed to continue until the completion of the said recruitment process. He has further relied upon paragraph 5. He further submits that the Honorable Supreme Court has further held that the persons who are selected to the post of non-judicial member of the State Commission and the members of the District Commission without having undergone a written examination followed by via voice, if already appointed and serving, in case the selection process had been completed prior to the decision of the Limaye, that's one Supra, such persons shall be entitled to complete their tenure in entirety. In the event of their tenure ending before the completion of the recruitment process under the new rules to be notified, their appointment shall be allowed to continue until the completion of the said recruitment. Full stop. Then counsel for the petitioner submit that the petitioner was appointed under rule. Which rule?
Rule 10.
Which rule? 22?
No, 20.
2020 rules, my lord.
Under the rule under 2020 rules. 2020 rules. 2020 rules. Full stop. Rule 6 of 2020 rules provide for procedure of appointment. And Rule 10 provide for terms of the office of the President and member. Full stop. He submits that. Full stop. Then counsel for the petitioner submit that after the order passed by the Honorable Supreme Court in the case of Limaye 1, another civil appeal was filed arising out of SLPC 36217 of 2025 within bracket Urmila Verma versus State of Rajasthan, wherein the Honorable Supreme Court has considered the case of Gyaneshwar Rajeshwar or Sulekar versus the Mahendra Bhaskar Limaye Supra, and held that notwithstanding in the said judgment, it was clarified that as an interim measure, the Honorable Supreme Court deemed fit it to appropriate to direct the appellant to be re-employed as a member within bracket judicial of the State Consumers Redressal Commission, forthwith ordered accordingly. The Honorable Supreme Court further clarified that the appellant upon reappointment shall be deemed to be continued uninterruptedly with effect from 1st December 2025 till the fresh recruitment is made or the rules are suitably amended by the state in consultation with the High Court. Full stop. Then counsel for the petition submit that after the order passed by the Honorable Supreme Court, several matters went to different high courts and referred the matter and relied upon the judgment passed by the Rajasthan High Court. In the case of Rajasthan High Court Advocates Association versus the State of Rajasthan, passed in DB Civil Writ Petition number 10174 of 2022, dated 18th of March 2022, wherein the Honorable Division Bench of the Rajasthan High Court held as follows. Para 6 and 8, चलो कैसा करेगा? In the case of Neelam Khare versus the State of Madhya Pradesh and others, passed in WP number 15378 on 2026, the Honorable the Madhya Pradesh High Court has also held that the president shall be permitted to continue on their post. The members and the president, the members and presidents shall be permitted to continue on their post even after their retirement or completion of the tenure till new rules are notified and appointments are made accordingly. Similarly, in the case of Tirunila Prasad versus the principal secretary, the Honorable Court of Madras, the Madras High Court has also held that the decision of the Honorable Apex Court is binding on the state, and the state is bound to give effect to the said order. And the Madras High Court
Para 5, my
directed.
Para 5, my lord.
Where is para 5?
5, 6.
They were directed to take necessary steps for giving full effect of the decision of the Honorable Apex Court, order of the Honorable Apex Court passed in the case of Ganesh Kumar Rajeshwar Rao Sulekar by appointing and by issuing appropriate order for reappointment of the president and the members of the state commission and the district commission within the state. Full stop. Similarly, the Kerala High Court has also allowed the president of the state commission as well as the members and the president of the state commission as well as the president and members of the district commission to continue in the post as temporary measure as per the rules prevailing when they are appointed till the finalization of the selection process and consequent appointment are made by the appropriate government. Full stop. The Learned Council appearing for the Union of India in its usual fairness submits that till date the central government has not notified the rules and the matter is pending before the Honorable Supreme Court for review of the order.
My lord, the miscellaneous application is pending, my lords.
This application is pending before the Honorable Supreme Court. Full stop. Learned Council appearing for the state submit that unless and until the central government will not notify the rule, the state government cannot act upon. Considering the submission made by the council for the respective parties, this court find that the petitioner was appointed as member State Consumer Dispute Redressal Commission on 1st of August 2022. Full stop. The tenure of the petitioner is going to be expired on 31st of July 2026. In considering the tenure of the petitioner, the government of West Bengal has issued the notice to the petitioner on 24th of June 2026 by requesting to hand over the charge to the president of State Consumer District Redressal Commission. The petitioner. Full stop. This court find that though in the case of Ganesh Kumar Rajeshwar Rao Supra, the Honorable Supreme Court has held that, invert comma, this one. Held that, यहाँ तक है. Subsequently, in the case of Urmila Verma, comma, the Honorable Supreme Court has passed the following order. Eta kori din. Considering the said order of the Honorable Supreme Court, several high courts have extended the tenure of the president as well as the members of State Commission as well as the District Commission. This court find that the judgment passed by the Honorable Supreme Court in the case of Urmila Verma as well as the judgment passed by different high courts with regard to allowing the presidents and the members of the State Commission as well as the District Commission is squarely applicable in the case of the petitioner. Accordingly, the notice dated Notice dated 24th of June 2026 is set aside and quashed. Full stop. The respondent authorities are directed to allow the petitioner to continue as
The non-judicial member. Non-judicial member.
As member, state
member.
As member, State Consumers Dispute Redressal Commission within bracket non-judicial. Non-judicial is not recorded here.
Not judicial. Now I am acting as a presiding member, not judicial.
This court cannot do. Member, State Consumer Dispute Redressal Commission,
At
West
Kolkata.
Bengal, till the new rule is notified or new incumbent is appointed in place of the petitioner.
May I, subject to Lordship kind indulgence, as per instruction, I have an instructor to address the Lordship. I may be subjected to the harassment by withdrawing service vehicles. I may be transferred from here to Siliguri. At least there may be at least order in the same terms and conditions.
Matter of this application.
That is same term. First, the petitioner is leave to correct the cost title of the name of the of the address of the cost title in the name of the petitioner. Leave is granted to the petitioner to correct the cost title.
I'm
in course of the day.
I'm obliged, my lords.
I'm careful. Okay.
I'm sorry to
Thank you.
consume lot of time.
Thank you.
Obliged, my lords.
और किया हुआ है कुछ होगा बोला देखिए yes what is the 7 and 8
My lord, the petitioners before your lordship, my lord, we had obtained a loan from the Indian bank and the consortium of banks.
There was direction to file report. Report. There was a direction to file our exception.
And my lord, with respect to yes, my lord, we're just giving this. My lord, we've handed over our exception to them as well. This is our exception to the report.
yes
My lord, we had obtained loan from the bank in the names of our companies, and thereafter, my lord, certain personal guarantees were provided by us as collateral and securities. Now, my lord, the subject matter of the properties that were mortgaged with the Indian bank, some of them are the subject matter of attachment by the Enforcement Directorate. But, my lord, the personal properties that we are seeking release of, which were collaterals and securities, those, my lord, are not the subject matter of the attachment proceedings
what
of
is
the
the prayer release
my
of
lord,
the
for
property
release of those collateral and my personal guarantee, lordship.
Which is with the bank.
which is with the bank.
Ah.
Bank is refusing, my lord, to refuse it on the ground that an NOC from ED has to be sought, although these properties do not become the subject matter of any proceeding before them. This is, my lord, the sum and substance of the matter. My lord, the properties include our life insurance policy standing in the name of the writ petitioner number 1. Then, my lord, another life insurance policy, pledge of FD, and my lord, our personal guarantees.
What is the stage of the ED proceeding?
My lord, the provisional attachment proceedings are over. It is pending for final adjudication.
An adjudicating authority are not decided that.
No, my lord.
Before the preliminary inquiry, whether this property were in the list.
No, my lord, they were never on the list.
Not on the
No.
list. And the list is provided to you.
My lord, it is part of the attachment order, lordship.
Yeah, where
I
is
will take your lordship to that, my lord. My lord, it is at page number 270 of volume 2.
270.
270, lordship. It starts from there. The order starts from there. The properties under attachment, lordship.
The bank has not initiated any proceeding against you.
No, my lord.
Only with regard to the bank. These are collateral security with the bank.
It's collateral
Bank is not-
securities. No, my lord.
Bank is not releasing that.
And my lord, the entire loan is paid off, and they have acknowledged that. It is part of their report as well.
Yes, how the bank can say?
Table
Bank has taken the documents from you. The ED has taken the document from you.
ED, lordship, there is an initiation of ED proceedings.
Correct.
Fact remains the directors in both the companies is common the Vikas Bansal.
Correct.
And the Vikas Bansal has really been investigated by the ED.
Correct. Correct.
His residence has also been investigated.
No problem.
Certain documents have also been attached.
Correct.
And they have been
We
returned.
have received a document from the ED for attachment for provisional attachment. Admittedly, provisional order of attachment has been passed. Till today, final order has not yet been passed. And if you not see,
Provisional attachment order of what?
provisional attachment order relates to the.
My lord,
company
page
who-
273. My lord, page 273, those are the details of the properties provided. But I am not seeking release of these.
Then I would like to, our contention is since we were in receipt of the notice.
No, you are in receipt. You are in receipt, but you are receipt with the, what is the details?
The details, Your Lordship, rightly pointed out.
Then
273. But then three pages I would like to go, Your Lordship. Kind attention thereafter, Your Lordship, I leave it to Your Lordship. Because we are concerned with, we are in receipt of the ED notice. Vikas Bansal in both the companies are identical. He has been in detailed inquired, and there may be in future.
What are the document with you?
Lordship, kindly take trouble to page 85, 185, the FIR. Why we are concerned? We not intend to attach their property.
Well,
unnecessarily.
we are not
Hold
named
there.
in the
Madam,
FIR.
please. Madam, please. Kindly allow me.
Yes.
Lordship, kindly take trouble to page 185. The 185 is a part of the piece and parcel of the interpretation of FIR. The Lordship, the clause 7. Unknown official, officers, railway, other department, unknown private person. If Lordship in future, if it is found that the Vikas Bansal, who is the director of the company, who stood as a guarantor, corporate guarantor or individual guarantor, another petition, Vikas Bansal is independent guarantor. If unknown person, unknown private person, if the investigating authorities came to conclusion, for say, if the Vikas Bansal also it does. So we are having the property of Vikas Bansal, then we, the bank, being a nationalized bank, we will be in trouble. Because we have
Where is the notice of the ED to you?
the ED notice to Lordship. Everybody has to serve. Page 1.
No, where is the notice of ED to you for attachment?
SCR report. Lordship thereafter. Lordship page 191 is the SCR report. Enforcement case.
That's not
You
what
are telling that you have received the information from the ED that this property is to be seized.
Yes.
Correct. And where is that letter?
Just now you have raised.
You have submitted the
No,
report.
you have
Why you have not
submitted.
submitted that? Where is that?
Lordship, page 91, one by one. Lordship, page 91 is the ECS information report. Thereafter, provisional order of attachment is appearing at page 195. Provisional order of attachment. Lordship, the provisional order of attachment. Lordship, internal. If Lordship kindly go to the page 196. The first proceeding conducted by ED. Page 195. Start the provisional order of attachment.
195.
Volume 2. Page 195, volume 2. Lordship, the provisional attachment order. Lordship, kindly see page 196. Why we are worrying the bank being a nationalized bank? Your Lordship, Roman 4, searches proceedings conducted by ED. Lordship, Roman serial number 2, Vikas Bansal.
Yes.
In another petition, item number 8, the Vikas Bansal is the petition. Here the Vikas Bansal is one of the directors. Lordship, thereafter, the Lordship, page 197, the statement of person recorded under the provision of PML Act 2002. The serial number 1 is Sri Vikas Bansal has also, his statement has been recorded. Lordship, thereafter, this provisional order, your Lordship, the observation of the ED, the prima facie case has been established. Lordship, then details of such conducted by ED, page 204. The ED is also conducted their inquiry. Page 204, serial number 2, Vikas Bansal, 1 second. Lordship, thereafter, your Lordship, Vikas Bansal's statement has been recorded by the ED, 205, Roman 7, Roman 9. Thereafter, your Lordship, Roman 207, Roman 10. Your Lordship, thereafter, the company who indulged in all these frauds, page 212, Spark Damodar Private Limited, Sonic Thermal Private Limited, where the Vikas Bansal was the director. Now he is claiming he has resigned from this, but admittedly he was the director of that company also. Thereafter, take trouble too. Can you take trouble to the page? The provisional order of attachment at page 225 at the last, at the bottom, the order is there, page 225. At the bottom, under the heading order. The order of a provisional order of attachment has been passed in terms of the schedule, which my learned friend was referring before your Lordship. And Lordship, kindly see the next page of 226. Here, this order of attachment has been served upon the following persons, including State Bank of India and Indian Bank.
Yes.
Lordship, here too, the copy has been forwarded to Spark Damodar, Sonic, Vikas Bansal, Chief Manager Indian Bank, serial number 6. The Chief Manager Indian Bank, serial number 7.
Correct.
So this order of attachment has been served upon.
Correct.
Upon perusal of the entire statement and ED proceedings, we came to learn that the Vikas Bansal, upon those two companies against whom the ED and CD proceedings is continuing, Vikas Bansal was the identical person who is the director of the company. And if you look at the law is well set at the lifting of corporate wealth. The companies are run by none other than the directors. Since admittedly it's a provisional order of attachment, and Vikas Bansal is also a party in this proceedings, as because he has been detailed inquiry has been made by the EDs.
What are the collateral? What are the security before you?
The securities, Lordship, to the companies who were in, as per the schedule of the ED attachment order, that has not been released. So far as the part of the petitioner.
No, I am asking what are the collateral security with you with of the petitioner?
The immovable properties belongs to the petitioner, Lordship. The immovable properties belong to
immovable property. No, immovable property is in the schedule of this.
No, not the part, piece and parcel of the schedule.
Then
my submission before Lordship, loan has been repaid. We are not on that. We are on that since Vikas Bansal and the petitioner is already a party before the ED proceedings. and provisional order has been passed, final order has not yet been passed.
That's what, see, there are two things.
Yes.
What are the collateral security is with the bank.
Yes.
Correct.
Yes.
With the bank. Whether that collateral security is with regard is appearing in the provisional order.
No.
No.
Ultimately not.
So if it is not, if I submit a letter to you,
कौन बच्चे?
I submit the letter to you without any order of the court.
Yes.
Can you say yes? The letter has come from X and I will not allow you to operate.
We have not said. We have simply said to the petitioner, though the document is also appearing.
You do one thing. You made the ED as a party.
Yes. This is our
made a ED as a party. Issue notice. Let they come and they say that yes, that is not the here.
My lord, they have written to ED. My lord, they have written to ED. There has been no response
That's
therefrom.
correct. See, they are the authority.
Understood, lordship.
If this provisional order is given to the bank has some authority.
My lord.
Correct. Though you have cleared the loan, and as per this, let the ED come and say, then if it is not in the provisional order, how the ED can say? Let the ED, you made a party to the ED. Here now I am making an order.
My
You
lord,
add
to
the ED,
impede
issue the
as a
notice.
party. My lord,
Let
we
they
issue
come. If they will say it is not, then the bank has no.
Actually, kindly fix it.
This court find that. No, after going through the report submitted by the bank, this court find that the ED is the necessary party to adjudicate for proper adjudication of the present date application filed by the petitioner. Accordingly, the petition is directed to add the enforcement directorate as respondent number 5 in course of the day. Today itself you do that in course of the day, and to issue notice upon the enforcement directorate and to file the affidavit of service on the next date fix. List the matter on 18th August.
3 p.m. lordship.
3 p.m. अगस्त में कोई डेट है क्या? टाइम है नहीं. Then it will go September. August 3:45. 3:45. 27th August at 3:45.
Deeply lopsided.
Item number 8 the same.
It is the,
I have filed my report in item number 8 also.
my lord, we have filed our exception in that.
In that ऊपर में लिखो report filed by the bank, report as well as the exception filed by the parties be kept.
My lord, leave to correct the cost title to.
That I have given. So you correct in
Yes,
in both the cases. I am
Yes,
passing
madam.
as-
Correct in both.
We don't record has left. Mercy will kindly make it tomorrow.
by tomorrow कर देना. Correct the cost title by tomorrow.
Deeply obliged. My lord, the 3:45 p.m. madam.
Yes.
My lord, the
I
interim
will take
order-
at 4:45.
My lord, the interim order will expire, my lord.
Thakkar was making his submission. Lordship will fix a date, Malad, any day. Right? We'll conclude in a day, in one session.
What can be done? One or the other matter.
Yes, Malad, that
has
is
to see all
understand.
things. If I have not taken that matter, the poor chap would be sacked from the committee.
Yes, right.
Though the matter is fixed today for hearing, especially fixed, and though the matter is specifically today for hearing, but due to at 3:45 p.m. but due to paucity of time, the matter could not be taken up for hearing. But it is 4th August. The Land Council for the petition submitted that the interim order is till 4th August. The interim order may be extended and a specific date may be fixed for further hearing of the matter. In view of the submission made by the council for the parties, let the matter appear on दो डेट दे दो 9th and 10th September 2026 or until at 3 p.m. as a
3 p.m.,
specially fixed
yes.
matter. Interim order is extended till 14th of September 2026 or until further order whichever.
Grateful, grateful.
Great.
9th.